restarting the district plan hearings. We're in stream 2, day 1. In terms of procedural matters, the only thing I noticed is that yesterday afternoon, Commissioners and I tiki tour around the residential suburbs of Wellington. So we cruised around Hataitai, Miramar, Strathmore down Broadway, Kilburnie around the outskirts of Kilburnie, South Newtown around the zoo, down to Island Bay, the back end of Mount Cook, up to Brooklyn, cruised around the limits of the Brooklyn area that Kaingaroa are seeking to rezone, Karori, cruised down Karori Road, back up Beecham, around the back, out Chater. We walked up Selwyn Terrace and Newlands, and then came back through over the bridge to Johnsonville. And so we've seen most of residential suburbs that are at issue. Stream 1, we had a good look at Johnsonville, and we had an extensive discussion about whether the Johnsonville line is a rapid transit service and the implications of that for high density around the rail stations on that line. So I think that's all the procedural issues from the panel's point of view. Mr. Wellington, anything from the council team?
I'm here to assist, but actually, since we'll be doing, I don't have any submissions to present, for example. So.
Yes, well, I'm pleased that we have the pleasure of your company, because I have 2 legal issues to ask you about, arising from my review of the submissions that are pre-circulated. There are any number of legal issues, but 2 in particular I want to explore with you. But I want to introduce your team first.
Well, I'll leave it to Mr. Patterson to do that.
Okay. The Mr. Patterson, would you care to do the honours? Mr. Wellington, we know.
Yeah, kia ora, panel. So my name is Josh Patterson. I'm a principal policy planner on the team. In the district plan team. I'm the lead author on the Section 42A report, and my qualifications experience are as set out in my Section 42A report. To the left of me is Mitch Lewandowski. He is a co-author, so he authored part 4, which is character precincts and character precinct design guides. As you know, you know Mr. Whittington, so I won't introduce him. And over there in the stands we have Dr. Farzad Zamani and Miss Shana Curl. They are our expert witnesses for urban design. And to note, we also have Mr. Philip Osborne from Property Economics. He is on call if any questions come up in terms of development capacity or any economic matters. We can contact him. And just to note that Mr. Osborne provided economic advice in relation to our recommendations on character and in response to Mr. Michael Cohen's evidence from Kāinga Order.
So we'll observe this. So we'll clear away the legal issues first, then ask, well, maybe Mr. Patterson, you can tell me, I have a run sheet. Is that how you intend to proceed? Run through your...
Yeah, so what I thought I might do is, if it's useful to the panel, provide a brief overview or introduction on where we're at. And then Mr. Lewandowski, if he could do the same for character precincts. I'm happy to suggest that happens now, or we can wait until you want to address character precincts. I'll leave that up to the side. So shall I get into my overview now?
Well, I think I want to explore the 2 legal questions first.
Okay.
And then I think my preference is to hear Mr. Lewandowski's overview first rather than wait until as a precursor because of the interaction between the character precincts and the character areas, character areas and the provisions of the residential zones. The other thing, Mr. Patterson, so you can prepare yourself mentally, while I talk to Mr. Wellington, I'd like you to take us through the logic of the two, as part of your overview, take us through the logic of the two zones. I don't think we need, we don't need an outline of the large lot residential zone, but really a roadmap of how they're structured, why are they structured that way, how do they interrelate with the district-wide rules, how do they interrelate with the precincts, how do they relate to the qualifying matters, particular character areas, and you can flip a coin as to which one of you deals with that. Is that the kind of question?
Thank you. That's exactly what we need. I think Mr. Patterson and Mr. Lewandowski don't assume that we understand the mechanical aspects of the plan. We might think we do, but it's important that we get those sort of factual mechanical matters set out. I mean, I've got a number of questions that I can assist in your overview, but really, I mean, things like how was the general residential zone split up and how was it delineated between HRZ and MRZ? What was the process? What are the various percentages attributed in terms of land area attributed to that? And then how do the rules work in relation to qualifying matters, triggers for design guide, and what the salient aspects of the MRZ and HRZ are. But I can remind you of those things as you go through.
The other point to make an introduction is Commissioners McMahon and I have just come out of the Paurora IPI. We have firmly fixed in our mind the zone and rule structure of the Paurora plan, and so one of the problems, well, commissioners used to doing this, one of the problems I have, making sure that I'm fixed on this structure and not the Paurora one and don't mix up the two. So if you think that the question I've asked doesn't seem to fit the plan that you're dealing with, that's probably the reason. You just need to tell me. Mr. Wellington, two questions. The first is that there is a consistent theme running through the legal submissions for Paurora, for Wakapatahi, and for HUD, that there is a heightened Section 32 test for qualifying matters in terms of assessing costs and benefits. Clearly there are additional elements in sections 77J and 77L, but insofar as those provisions require an assessment of costs and benefits, what's your reaction to the premise of, or the submission? For some it's an implication, but some of the submissions are rather more direct than that there is a heightened requirement to satisfy ourselves of costs and benefits of not implementing the mandatory directions of the SUD.
Well, as you know, I agree with the thrust of those submissions generally. I think the answer in the Wellington district will depend on the extent to which the 32 and 42A reports. The answer to whether there's two questions there. One is what are the requirements, and then secondly, have the Section 32 and Section 42A reports met those requirements, and that requires me to get really into the detail of those reports, which I can do perhaps later today, once I've gone and identified the passages that I draw to your attention, perhaps, or in writing, if that would be easier. But that, I mean, I'm in your hands as to how you'd like to proceed. I don't have the precise passages.
So, for instance, section 77(3)(c) requires proposed amendment to accompany a qualifying matter to assess the costs and broader impacts of imposing those limits. So my question is that any different to the section 32 test that would apply to any provision?
Well, yes, I think it is different. It's the question is, how much more stringent is it? It's a question that you.
Well, that's another way of putting it.
And
Is if it's different, how different?
yes, and that's a question you'll have to grapple with both in Porirua and here, and I would agree on behalf of the council that it is more stringent, and I think the best way to discuss how much more stringent is by reference to the work that's been done, the section 32, the evidence that underlies that, and then the section 42A report in response to submissions.
So, so your overall submission is yes, it's different, but the council's analysis satisfies, to the extent that it's different, the council's analysis satisfies that.
That's right. For example, I know that one of the Kāinga order submissions is that under, I think it's section 77LB, there's no weighing up or no consideration of the national significance of urban development as against the restrictions that are being imposed by qualifying matters. And my response to that is that what that section requires is not a heading in a report that expressly goes through that. That's a question for you to determine on the whole of the reports. Are they consistent with an identification of the national significance of urban development? Has that been brought into the minds of the report writers in terms of giving effect to the legislation? And when those qualifying matters are being addressed, has that issue as a whole been addressed? Not is there a paragraph in a report that addresses it just, directly?
I'm sure that Angora won't contend that the absence of heading is critical.
No.
The question is whether the substance of the requirement has been met.
That's right.
I think for my part, I do want to understand where you say everything is, and I think that we should probably do that before we hear from Mr. Lewandowski on Clarence, since that goes to that, essentially to that point, while it has broader implications. That's where the rubber hits the road.
Yes. Well, I think in terms of the timing then, if that could be put off, I know he's got issues tomorrow, so if that could be put off till this afternoon, I can then work with him in the breaks to identify the particular parts that he worked through when he was doing his work.
Okay, so we've got 2 days scheduled here, the council case. As far as I'm concerned, how you arrange those 2 days is up to you.
Yes.
I'll only get excited if we get to 4 o'clock tomorrow afternoon and we haven't finished. The other legal question is the submission of Mr. Hinchy for the Retirement Villages Association for Ryman, that the structure of the design guides is inconsistent with the MDRS policy that requires that the plan provide for non-permitted activities and encourage good design. I think that's what it says. That's my recollection. And his submission is that this plan does far more than encourage good design. It requires what it considers to be good design through a series of mandatory directions. And so the question is, what's your response to that submission?
I'll have a think about that and come back to you on that one as well.
Yeah, Mr. Counsel.
Thank you, Chair.
Got to press this button too.
Sorry. Is that coming through now?
Oh,
Yeah.
If it's on, it just.
It just needs to be a bit closer. So what I might do then is I'll go through what I've prepared in terms of an overview. And if you can, I'll try and cover off what you asked for previously, but if you can remind me along the way, that would be much appreciated as well. So firstly, I'll just start on how we've structured the section 42A. So we've decided to split that up into 6 separate parts. As you know, part 1 provides an overview and addresses general submissions. Part 2 addresses submissions made on the high density residential zone. Part 3 addresses submissions on the medium density residential zone. And then part
Mr. Patterson, are you reading from a prepared script? Or
yes.
will we have in the interest of economy, will we have access to that? Because
I can make it
to
accessible.
determine how much notes we take.
Okay. So shall I skip this part then? And
No, I'm not suggesting you skip it. We need to hear it. But I just would have been nice to have that in front of us while you were reading it.
apologies, I can make that accessible.
You could email. You could email it to Jazz. He will file forward it on.
Okay,
That would help online.
sure, I can do that. I'll ask Jazz to do that once I've finished. So part 4 addresses submissions on the character precincts and the character precinct design guide. Part 5 on large lot residential zone, and then part 6 on the design guides. The reason the report was structured in this way was to help with readability and provide the ability for the panel and submitters alike to isolate key parts of interest. And just note, I hope this was useful for yourself, submitters. I thought it also might be useful to give a brief overview of how we got here, basically, how we got here to a hearing on the proposed district plan. And I'll start right from the beginning with the Our City Tomorrow framework, which evolved into the first spatial plan. So the council initially engaged with all of Wellington City on the challenges that the city faced in terms of population growth. The outcome of this engagement was that residents wanted the city to be compact, resilient, vibrant, and prosperous, inclusive and connected, and greener.
No challenge then.
What's that, sorry?
No challenge then.
Yeah. And then during this process, the NPS on urban development was released, so that required specific density to be achieved. Taking into account both what we heard from the community and what the NPSUD requires, we've developed the first draft spatial plan.
What sort of dates would be useful, Mr. Patterson? Was this post late 2020, was it? Or?
That is back in 2018, I believe.
Okay. So you're
Pre-NPSUD.
talking about the MPS UDC.
Yes, MPS UDC. Just let me bring up dates so that I don't steer in the wrong direction. I can't find the nice helpful graphic that I had, so maybe I'll come back to that if that's okay.
We're talking about, or can you tell us when our City Tomorrow framework was prepared?
Yeah, so that led to the development of the spatial plan. The city framework did. So that had the consultation with residents, the initial consultation that council undertook.
And that was around circa 2018, are you saying?
Correct. Yeah, yeah. In the development of the spatial plan itself, the draft spatial plan was released around mid 2020.
The MPSUD was July.
Yeah, so that took into account the MPSUD requirements.
How could it?
Well, the spatial plan preempted that coming and attempted to look at growth in terms of what they require and from the catchments of public transport and centres. So the spatial plan didn't say this is the zone, it just provided areas where growth should be focused. Correct. Yeah. So that plan itself received 3,300 submissions, which we thought was quite significant. And as I said, foreshadowed the fundamental shift from the operative district plan to the now PDP or proposed district plan.
In what respects did the foreshadow a fundamental shift?
In what respects?
Yeah.
So the shift from sort of your 8-metre heights, your 2.5 metre and 45-degree recession planes, to now what's required under the NDRS, which is that at least 6 stories within walking catchments, the 11-metre height limit across all of the residential area at least. So yeah, quite a significant shift in terms of the planning framework that was in the operative district plan.
So that level of detail was actually contained in the draft spatial plan?
No, so that the draft spatial plan foreshadowed that level of details in the draft district plan, which I'll explain next.
I guess, I mean, you're saying it foreshadowed it in more general terms,
Yep.
that there would be an increase
Correct.
in
Yes.
intensification as a result of the recent, at that time, the recently gazetted MPSUD.
Correct. One of the key issues that came out of the spatial plan consultation was character, unsurprisingly. So I'll let Mr. Lewandowski go into character, but just briefly. So but what this resulted in was officers recommending an increase to the extent of the character precincts from what was presented to councillors in the first spatial plan. We're now recommending we go back to this, but again, I'll let Mr. Lewandowski explain that further. He's more across it than I am.
Sorry to keep interrupting, but did the first spatial plan actually delineate character areas?
I would need to go back and check, Commissioner. My involvement's been a little bit intermittent, so can I go back and check that for you?
I mean, look, I apologise about the interruption. I'm just trying to get a feel for the, as you're trying to outline, Mr. Patterson, the way in which this has progressed and how themes that have emerged have been dealt with. So, I mean, when you say the spatial plan foreshadowed 6 stories and 11 metres, I mean, was it more of in a generic way than specific detail? And in the same way, were there specific character areas identified or not? Or was that just the subject of the draft plan?
Commissioner, the draft spatial plan did identify character approach. It was slightly different at that time, sir. It was a it identified proposed sub-areas, just looking at the map. Also identified areas to be removed from the current.
And reading ahead, and particularly your report, Mr. Lewandowski, where you're signalling a move back towards some of those areas that were identified in the spatial plan in your recommendation, in your rebuttal well, not in your rebuttal, in your 42A.
I'm seeking to return to the areas that were recommended to council in the finalisation of the spatial plan, which were knocked back at that point.
Okay.
Thank you. So now move on to the development of the draft district plan, which as mentioned, the spatial plan informed. So the draft district plan gave effect to the NPSUD. However, it did not give effect to the MDRS under Schedule 3A of their RMA. These changes were made. Oh, sorry, this came in a couple of days before the release of the draft district plan for public consultation. And so these changes were made and incorporated into the proposed district plan once consultation had concluded. Just an important note is that we have constantly needed to be flexible throughout the development of the PDP in relation to changing government policy, and we've tried to do this as efficiently and effective as possible, but it has been a challenge.
AKA shifting goalposts.
Correct, yeah. So the draft district plan took the general approach of balancing the need for intensification alongside the protection of important attributes such as we touched on, character and other important things like heritage. So the draft district plan recognised that while we need to provide intensification to meet our legislative requirements and to ensure there is enough residential capacity to meet demand, important amenity features of Wellington City also need to be protected. The draft district plan was consulted on with public in May 2021. This in turn led to the development of the current PDP. This PDP was notified in July 2022. It was refined from the draft district plan, taking into account the submissions received on the draft. It does give effect to the NPSUD and to Schedule 3A of the RMA. And it also provides more than sufficient residential capacity to meet the expected demand. I believe this is covered in detail in hearing stream 1. And also, I'd just like to note that engagement with neighbouring councils across the Wellington region was undertaken throughout the development of the PDP. And we've also taken into account regional initiatives, such as the Wellington Regional Growth Framework and the Regional HBA, which is the Housing and Business Capacity Assessment required under the NPSUD. So the residential chapters themselves in the proposed district plan received 3,231 original submission points, 1,327 further submission points, with a further 451 original on design guides and 137 furthers on design guides. All of these submission points were summarised, and that summary is contained within Appendix B of my Section 42A report. So the submission points have informed my recommended changes to the residential chapters and the residential design guides. What I intend to do now is briefly summarise the key recommendations and issues within the parts that I authored. So that's high density residential zone, medium density residential zone, large lot residential zone, and the design guides. I'll leave the character precincts to Mr. Lewandowski. So now I'm going to get into those key recommendations. Is there any further questions before I do that?
I wonder, before you get into the key recommendations, you could give us the roadmap we talked about. Yeah, how is this whole thing structured?
So what you were asking is how it's structured in terms of the high density residential zone.
Like starting from the 2 or 3 residential zones you have, how you identified the areas within which the criteria that were applied, as the Commissioner said, to what extent, to the extent there was a general residential zone, the ODP, how was that broken down? How does it differ from that? And then how are the district-wide matters, precincts, qualifying matters, how are they structured? Why were they structured that way? Like, I think in reality we probably know how they're structured, but it's the why we're more interested in.
Okay, so the general residential zone in the ODP no longer exists in the PDP. What replaces that is the medium density residential zone. And the reason for that is to align with the requirements under Schedule 3A of the RMA, as well as the NPSUD. So the medium density residential zone provides a height limit of at least 11 metres across the city, and also increases to 14 metres in areas where there's specific access to facilities such as public transport and centres. The high density residential zone, that is a new introduction, obviously, to the PDP. That is based on the analysis done on walking catchments from those key public transport areas, centres, and other amenities, which is in my mind. And that is to achieve that at least 6 stories within the walking catchment area. And I believe the walking catchments were covered in detail in hearing stream 1.
Correct.
Yeah, so I won't go into those. But the high density residential zone responds to the NPSUD and increases height limits and density in key areas where there's good access to those facilities. The large lot residential zone was formed for those sites which are on the urban rural fringe, where they do not make sense as rural zones because they're not used as rural zones. They're generally smaller than your typical rural zone, but they also generally larger than your typical medium density residential zone. And as I said, are located on that urban rural fringe. We have used qualifying matters, the more significant one probably being character. I will ask Mr. Lewandowski to touch on that in his presentation. So I won't go into that, just here. We've also used other qualifying matters such as heritage, which is your section 6. Natural hazards, which is also section 6, and then we've got other ones in there as well for the national grid yard. So recognising that's a matter of national, or sorry, that's a critical infrastructure across the country. So all of those will have limits on how the NDRS can be applied, and those provisions are contained within their relevant chapter. So important to note that although you're looking at a residential chapter, you also have to consider the general or district-wide matters on top of that, which is noted within the introductions of the, of the chapters.
How have you handled 3 water capacity?
3 waters capacity has been addressed in its own chapter under district-wide matters, so that will need to be considered on top of the residential provisions.
Is that a qualifying matter?
3 waters has not been treated as a qualifying matter.
Does that mean that it can't lead to reduction in scale or intensity of development in residential zones?
Off the top of my head, sorry, Chair, I cannot recall what the provisions say, so I will have to look into that and get back to you.
I think you should do that. I think there are a number of submitters who have expressed concern about layering the extent of development the plan provides for against an already stressed Three Waters network.
Just, Mr. Chair, just for my 5 cents worth, the core rule provides for connections as a permitted activity, up to 3 residential units. So there is your alignment with your MDRS standards. The other basis for that as a permitted activity is compliance with the relevant Wellington Water Regional Standard for water services, and then it tips into a discretionary restricted activity after that. I'm going to probably stop there because I'm a little bit over my skis, having not worked on that chapter, but that would be my sort of on the fly advice to you in response to that question.
So it's an RDA if it doesn't meet Wellington Water standards, and
or is for more than 3 units. So there's the alignment with MDRS, of course, at 3.
I suppose structurally, if it's an RDA, it can be refused. How can that not be a qualifying matter? And or how can it be considered not a qualifying matter?
I'm going to take my leave of this discussion. I'm sorry, I'm just not familiar with this chapter at all. I haven't been involved.
I appreciate your assistance, but like, and I'm not expecting an answer to that in the air, but I think it's an issue we need to grapple with.
I think you're right. I think it might not be couched as a Section 77J matter,
But the
but
question is whether it should be.
yeah, and whether the output or the outcome, of the intersection of Three Waters chapter with our MDRS provisions and the bundling approach might not lead to a qualification of density in terms of both height and density.
But if the answer is that consent can be refused, that's pretty qualifying of density.
Yes,
Sure. Yeah, like you say, Mr. Chair, we will have to go away and have a look at that and come back to you on that question.
Okay, leave that curveball in your hands.
Before I carry on, was there any?
I think that's probably enough to be going on with. Oh yes, go for it.
sorry. So just so I've got it in my mind, can you recall the residential zones that made up the operative district plan?
Yeah, so you had the outer residential zone,
Yes.
the inner residential zone. You had the specific MDRS overlays within those zones. So they are in the chapter themselves, the outer residential zone. And you also had the rural zones.
When you say MDRS, you're not using it in the sense of the Schedule 3A, are you?
Yeah, apologies, that could be confusing. No,
Yes.
I'm not.
So okay, tell us what you do mean then.
So those are the I forget what they're called, but they're essentially medium density residential areas within the outer residential area, and I believe they're specifically around Newlands and I think Johnsonville, and Johnsonville, and they provide some increase in density. I can't recall.
Oh, yeah, that's right.
Is this
While we were on our site visit, Commissioner Dash pointed out the area that was the subject of a special height limit.
I think it was MDRA, not MDRS.
Yes.
Yeah, so MDRA, that's right.
And I presume these were the provisions that were brought in Plan Change 72 and 73
Yes, correct.
back in 2010 or 2009, 2010, around then, was it?
Yeah, somewhere around there.
Might have been slightly later because I'm sure that the Environment Court case about the Johnsonville MDRA is 2012. So it might have been introduced 2010 Environment Court stage.
I sat on that
2012.
hearing, Mr. Whittington.
Yes.
I think it was.
I'm shocked you can't remember the date.
I relate most things to the Christchurch earthquakes, and the hearings were pre-Christchurch earthquakes, but the Environment Court decision was post-2011.
Yes.
Yes, everything. I think everything in the Commissioner's life is pre and post 2011.
It is a sad but true fact. The reason I asked that question is not now, but I think it would be useful to know how the medium density, sorry, I'm going to use the right terms, the MRZ and the HRZ relate to the outer residential zones and the inner residential zones and that MDA area. Now it's going to take a little bit of work, I imagine, in terms of spatial fit and what the differences are really.
So just to confirm, do you want to see that on a map, or?
If you're able to do it on the map, that would be great. But you know, if you can tell us that the residential tent, if you like, in the ODP was comprised of outer residential zone and inner residential, and within the outer zone there was some MDA. If you could give us the proportions that made up that, that would be useful. And then if you could do the same with the HRZ and the MRZ and I guess the large lot. And I just want to get a feel for the changing proportions across the operative plan, proposed plan.
Sure.
But in broad terms, where were the limits of the inner residential zone? How far did it stretch? How inner was it?
Yes.
So we're talking your Thorndon area. So you're talking your central area, and it's directly around that. So you got Thorndon, Mount Vic, down to Newtown. And I couldn't tell you what the distance is or anything.
Basically, it was the old Chiaro flat.
Yeah.
And generally, what were the sort of key bulk and location standards, particularly height in relation to those outer residential zones and inner residential zones?
So your outer residential zone was 8 meters.
Yes.
Your inner residential zone, I cannot quite recall. I think Lewandowski is bringing it up.
Yep.
Yeah.
The answer is, Commissioner, that it was variable. But
Yes.
let me give you some parameters, perhaps.
Yes. While you're doing that, I'm just trying to establish the baseline and to get a feel for how the changes relate to that baseline.
So there's a few here, sir. Outer residential, Mr. Patterson's told you, is 8 meters, except for Roseneath, a defined area in Roseneath, which is 10. The medium density residential areas that you talked about before in Kilburnie was 10 meters, and Johnsonville was 8. The inner
You
residential.
say 8.
Sorry,
8.
8 for Johnsonville. MDR 8, but 10 for Kilburnie.
Yes. Which doesn't really differ from the outer residential zone, does it?
Yeah, I can't. That was before my time at WCC, sir, so I can't comment on whether that was an Environment Court change or.
Okay.
I'm not sure. And then in terms of the inner residential area, the baseline height is 10 meters, except where, and there's some variance here, Arrow Valley 7.5, Mount Cook, Newtown and Berhampore 9 meters.
So just slow down. Mount
Sorry,
Cook, Berhampore.
Berhampore, Newtown and Mount Cook was 9.
Yep.
Arrow Valley, I think I mentioned, was 7.5.
Yes.
Oriental Bay height area, noting that that was in a residential, is variable, as I think you're probably aware, on a site-by-site basis, but the range there is 13 to 34 above mean sea level. And the last one was what's termed North Kelvin / Bolton Street, and there is a range here of between 10 and 16, and that is with reference to an appendix, which obviously demarcates that.
Yes. Thank you. That's very useful. Would you be able to reproduce that for us?
Yeah, do you just want the height, or did I take you through anything else, site coverage or otherwise?
No.
No.
Well, no, it was more the height that I was interested in. I think I understand coverage rules. Mr. Patterson, I guess, oh, well, the first question, sorry if this sounds a bit basic, but does the MDRS rules apply solely to the MRZ? Or do they apply to the HRZ?
So these sort of your baseline, your minimums,
Yeah.
and they do apply to the MRZ. The HRZ goes above
Yeah.
the MDRS.
Okay, no, that's fine. And does the MDRS models that's included in the legislation and the MPS, has it been followed to the letter of the law and by council in adopting it, or has it's enabled to do? Has it changed it in any way?
It has changed it in terms of the height differences particularly. So you do have increases beyond what the MDRS says you must do. And I think a good example of that would be I'm just bringing it up now. You do have two different height areas within the.
Is that the 11 and 14?
Yep.
Yeah.
Yep. So it does go above that 11 meters that's required in certain height areas.
Is the 11 meters? I don't want to use the word qualified, but is the 11 meters nuanced in any way by bulk location standards? Like, have you applied the same setbacks, the same recession planes in relation to height?
Yeah. So we've done we've complied with the MDRS, especially in my recommendations, just noting that the side yard, or sorry, the yard standards, as they were proposed, did not include the side and rear boundaries, but we've taken those exclusions away, or we've recommended to take those exclusions away. Do those provisions have legal effect given those changes? No, because they're not in the proposed district plan at this stage.
Set of changes.
Yeah, sorry.
It goes like so the notified plan didn't include side and rear yards. Did that take immediate effect?
Sorry, I'll just make a correction. So the yard standards only applied to the rear yard boundary setbacks, so they excluded front and side.
The front and side.
Yep, and that did take immediate legal effect.
Front and side.
Yep. But in my section 42A report, I have recommended to go back to what the MDRS requires, which is your front and side and rear yard setbacks.
Front, side and rear.
Yeah.
Okay. And the areas subject to the 11 metre and the MRZ and those subject to the 14 metre, they're clearly delineated on the planning maps, are they?
They are, so they're in height areas, and there are spatial layers on the planning maps which delineate the two height areas.
Yes. Going forward in this hearing, how should we refer to those areas that are well, let me give an example. In Porirua, they call them height variation controls. They work both ways in Porirua. They've increased heights and they've decreased heights through the application of height variation controls.
Right.
So, for example, the 22 metres in the high density residential zone in Porirua is sometimes reduced down to 16 metres. 11 metres is sometimes increased to, I think, 18 or 16 metres.
Yeah.
But for various reasons, which are all being based on qualification matters. So there's intensification, there's additional intensification, and there's reduced intensification depending on which height variation control you're in. This 14 metres, is that the equivalent of a height variation control?
It sounds like it might be the equivalent. We've called them height areas.
Height areas, okay.
Yeah.
And is there more than one?
Yeah, so there's height area 1, which is your 11 meters,
Okay,
and there's height area 2, which is your 14 meters.
thank you. That's good to know.
But there's no further height areas.
Well, going forward, I'll refer to height area 1 and height area 2, so you know what we're talking about.
Sure.
Okay, nearly there, Mr. Patterson. These matters will all be obvious to you, but it's a bit of a learning curve for us.
Yeah, no problem.
In the HRZ, and you made the point that they're based on walkable catchments. We had a big discussion about that in hearing stream 1. The provision is for at least 6 stories, isn't it?
Yeah, so I'll go to what the height limit is.
Is that 21 or 22 meters?
So your height limit. Yeah, so that's must not exceed 21 meters.
21 meters. Yeah. And are there any height areas?
Yeah, so there is 2 height areas there.
Yep.
So building height control 1 applies where no more than 3 residential units occupy the site.
Let me just get building height area 1 was where no more than 3.
Correct, residential units.
Yes.
And your height limit there is 11 meters.
Okay. So that's sort of like the MDRS, isn't it? Within the HRZ.
It is, that's
Yeah.
right. And then for multi-unit housing, which we've defined as anything that results in 4 or more residential units.
Yep.
That is building height control 2.
Yes.
And your height limit is 21 meters.
21 meters. Okay. Which is the equivalent of the 6 stories.
Yes.
Yes. Okay, no, that's useful. Thank you for that. That's the mechanical aspects of the rules, the basics ones. Mr. Chairman, I'm still interested in how qualifying matters work in practice. Is that the appropriate time to raise those or later on?
I think the
Not so much in relation to character.
I think before we go there, should we just pick up how the areas that you've identified be amended, and then I'm interested in your reaction to the urban design joint witness statement and the extent to which that alters your recommendations. So,
Okay, if that in that basis, I've got one question that might help inform you, and that's just what are the triggers for urban design assessment? What triggers the residential design guides in both the MRZ and the HRZ?
So the residential design guides are triggered basically when you have a multi-unit development or when you require a resource consent as a restricted discretionary activity. And that's contained within the policy, the relevant policies themselves. And
so just remind me, what's a multi-unit, how's a multi-unit development defined?
4 or more.
4 or more.
4 or more.
Okay.
Yeah.
And that's across both the MRZ and the HRZ?
Yes.
So no differentiation?
No.
Okay. Or whether you trigger an RDA? Is that, and that might be because of increased height or setback, site coverage, those sort of things, is it? Is it bulk and location standards principally?
Yes, I think that is the case.
Would it also include the number of units?
Yeah, it does. Definitely includes the number of units because as soon as you cross that threshold to be a multi-unit, you
Okay.
are a restricted discretionary activity.
Okay. So conversely, if you've only got 3 units and you meet all of the bulk and location standards, the design guides are not triggered.
Correct.
Thank you. Thanks, Trevor.
Okay, Mr. Wilson, so to what extent have you recommended these be amended. We've already covered the side yards with the front and side yards.
Yes. So I'll go through the key recommendations now then. So across the MRZ and HRZ zones, we have recommended changes to the notification preclusions, particularly under MRZ and HRZ R14 and MRZ and HRZ R17. And those changes are to reflect Schedule 3A of the RMA, which says that public and limited notification is precluded if you comply with all the medium density residential standards. So that was something that was brought up in submissions and it wasn't quite clear within those rules. So we've made that clear and amended that, or recommended. As you say, we've touched on yards. In terms of setbacks, the only change that we've recommended there for both MRZ and HRZ is we've recommended a 1.5 metre setback from the rail corridor boundary. This is in response to Kiwi Rail, who asked for 5 metre setback. I've recommended 1.5 metre setback. I consider this to be practical space for maintenance and access to buildings, while at the same time not having a large impact on the on what you can do on a site.
Just while I'm thinking about it,
Yes.
what's the definition of the rail corridor?
So that's the outer edge or the outer limit of the designation within the district plan. Rail corridor.
Does it have to be designated for rail lines? Because of course presumably the whole railway station is designated.
Yes, yeah, I believe so.
Thank you. Sorry to divert you.
That's okay. And another one is for permeable surface. So as I touched on before, we've recommended that this is moved to the Three Waters chapter that aligns with the planning standards. Not removed from the plan completely, but taken from the residential chapters and put in the Three Water chapter.
And at the moment, you're not recommending it be changed, but that'll be, whether it's changed or not, would be debated in the Three Waters in relation to the Three Waters chapter.
Yes, that's right. In terms of fences and standalone walls, this applies across the 3 residential zones. We've recommended that any part of a fence above 1.5 metres adjoining open space boundaries be 50% visually transparent. That recommendation is mainly based on SEPTED issues and also response to matters raised in submissions. In relation to the outdoor living space for multi-units in the MRZ and HRZ, and in particular the communal outdoor living space option, I should say. At the moment, submitters raised that it was quite difficult to understand and interpret. We have acknowledged that and we agreed. So we've adjusted or recommended to alter that standard so that for every 4 to 15 units, 64 metre square communal living space with a minimum dimension of 8 metres.
Say that again. For every 4 to 15 units, 64 square metres?
Correct, yes. With a minimum dimension of 8 metres. And then every additional unit above 15 units, an extra 2 metres squared on top of that, 64 metres squared. Just to note that the requirement previously was for 10 metres squared with a minimum dimension of 8 metres, which didn't quite add up because 8 by 8 is 64. So hence the change, recommended change. In terms of height for the high density residential zone, I have recommended to increase the height limit for 1 to 3 dwellings from 11 metres to 14 metres. This also responds to submission points, but also reflects that the high density residential zone differs from the medium density residential zone. And I believe that that change there provides that differentiation. I also believe that this is more consistent with the 21 metre height limit for 4 or more dwellings. It's not so big a gap between the two. And in relation to the height in relation to boundary requirements, in the proposed district plan, submitters raised that the requirement for open space zones, so we've got a boundary adjoining an open space zone. At the moment, the requirement is that no more than 70% of that open space area is shaded. It was raised that that's quite confusing and difficult to comply with. We've acknowledged that and recommended to replace that particular standard with a 5 metre and 60 degree recession plane for boundaries adjoining open space. I believe that's clearer and easier to comply with for plan users and applicants. In response to the character areas, many.
So just make sure I'm right. The notified requirement was to ensure how much was not shaded.
70%.
So it's 70% or more.
Yes.
Effectively.
In relation to the character precincts, so you would have seen many submitters have touched on the issue of a buffer zone between character and the HRZ. We responded to that by recommending that 5 metre and 60 degree recession plane also apply to boundaries that adjoin character precincts. And those are the key changes that I want to touch on in terms of the residential chapters themselves. I also have some here for the design guides, if you'd like me to get into those now, or. Okay. So one of the key issues in contention with the design guides is obviously if they should remain in the PDP as a statutory document. We have received mixed submissions on this, and I have recommended that design guides remain in the plan. In summary, I believe that this will ensure design guides are fully applied and utilised as a key method for achieving the residential zone objectives, which is your high quality urban environment. Another key issue raised in the design, in relation to the design guides, is that the guidelines themselves read as standards. I have acknowledged this, and however, I point out that these are not standards and do not have to be complied with in the same way that standards do. I have recommended some wording changes, essentially to provide clarity and to point out that not every guideline needs to be complied with to achieve the intent of the residential design guide. So the main change there being some wording around clarity, introducing statements such as where relevant.
Could I just ask a couple of questions there? I'm not familiar with the design guides at all, so I understand there's some sort of dot system. Could you just explain how that works?
Sure. What might be helpful is if Ms. Curl or Dr. Zamani explains the dot system.
We can bank that one if you like. I just need a general overview of how they work and how that dot system works.
Yeah,
that's fine. I'm happy to wait.
Okay, thank you. Another key issue raised in relation to the guidelines is that submitters or some submitters feel that the guidelines can be conflated or brought in to make one guideline, some of them. I have recommended various changes to the guidelines to conflate some. Where I've not recommended that they be conflated, I do believe that it's necessary they are separate guidelines, and the main reason for this being that some details within those guidelines themselves may be missed if they were conflated. So I believe they work better as separate guidelines. And that's in my section 42A report. Another key one is I've recommended some changes to improve the outcomes for those who have accessibility needs across the design guides, again in my section 42A report. And the general sort of change being that I've provided or recommended changes which improve the clarity and provide flexibility within the guidelines. And that's all I had on design guides.
Does that, excuse me, does that include the wording that you have actually adapted from the impaired, what are they called?
Yeah.
Yeah, you know what I mean?
Yeah, I
The
think I know
Impaired
what you mean.
Association.
Yes,
Yep.
yeah, so that includes some of their recommended wording.
Yeah.
Yes, yeah.
Okay.
Talk about
We've taken-
empowerment rather than disability.
Yeah.
Yes, that's correct.
Yeah.
Yeah.
Okay.
And as a general guide, we've taken them as experts at that and taken on board their recommendations.
Can you explain to me what you see as the difference between impairment and ability? Because I'm not saying that the Impaired Association don't know what they are talking about. They are perfectly in their right to say this is what we want. I'm just wondering what where you see the difference of the meaning of the words, because I think that words can mean different things. And I'm just trying to get to the point of what do you really want to say?
Sure, I understand. Off the top of my head, I probably don't want to give what I think the differences are between
I
the two.
think the answer is that you need to stop
Yeah.
and think about it and
Great.
give us a considered answer.
That's what I'd like to do.
But and if that's the end of the summary, the question I asked about the consequences of the urban design JWS, to what extent does that alter your questions?
I have seen the joint witness statement, and I have noted that there has been some agreement between Dr. Zamani and Mr. Ray of Kainga Water. I am open to exploring options around providing relief for what was mentioned in the joint witness statement. However, I have not come to conclusions yet to how far I would like to recommend on that. So,
Like, effectively, if you're not going to adopt the recommended, you're going to need a planning reason. It's not related to urban design to justify that.
that's right, and that's what I'd like to have a further think about before answering that question.
I think you've got until about 5 o'clock tomorrow.
Okay. No.
To give us
Probably.
a list. Because certainly I think that Kainga need to know before they arrive.
Yeah.
If you've shifted ground response to the JWS. It'll at least Kainga, given that Mr. Ray is involved, but possibly other parties too.
If there are no further questions, there are. Yeah.
Just one for your list of homework, Mr. Patterson, and that's when you're providing us the percentages of land area. Could you, for the HRZ and the MRZ, could you distinguish between height areas 1 and 2 for both of those zones? Thank you.
The comment I would say is that this is for our general reference. This is not to multiple decimal points. This is there or thereabouts. It's just fine.
Okay. Take that as well.
Mr. Chairman, I'll bank those questions on mechanical matters on the qualifying matters, sorry.
Yeah.
Give an opportunity to come back to
Interrupt
those.
The mechanics of the qualifying matters now.
Okay.
What then I might do is ask Mr. Lewandowski to provide his presentation of the character areas.
Thank you. Good morning. I might start share with an overview of the chapter itself and how the precincts sit within that. And then maybe we jump to a broader discussion of qualifying matters in a statutory framing and how these are considered within that. The two that are relevant, but I think the parallel is also to the Oriental Bay High Precinct, which Mr. Patterson holds the pen for, is that they have been identified as precincts rather than a different spatial tool such as an overlay.
So say that again.
They've been identified as precincts in terms of the spatial tool used rather than an overlay, and that is with reference to the national planning standards.
Practical.
Yeah,
What's the practical effect of that? Is it just semantics, or is it?
to a degree, sir, but looking at the description in the planning standards, suggests that precincts are to be used if they apply to one zone and they therefore sit within that associated zone chapter.
Okay.
Conversely, an overlay sits
Across multiple zones?
yes, it's of course across multiple zones and therefore sits in district-wide chapters within district plans. Slightly different for a combined plan, but that's off topic for us. So there was some debate around the appropriate tool used, but in the end, I think the answer is relatively clear as to which one is appropriate in this particular context, because we are framing ourselves as being within one zone.
So as a character, we're calling them character precincts, are we?
Correct.
Do they apply to both the HRZ and the MRZ?
Solely MRZ.
Solely MRZ. Okay.
The Bangor are submitting that even if character areas are retained, an underlying HRZ should be defined walkable catchments, which would include all of Mount Vic effectively. Would that, if we accepted that submission, would that alter your recommendation as to the appropriate planning framework? Because of course they're pressing for use of, if again, character as an overlay rather than a precinct.
Yes, I think there's a couple of things there. The character as an overlay as included in the Kaingaora submission.
Yeah, clearly their vision of a character overlay is not the same as what your vision of a character overlay. Just take that as a given.
Yes, yes. So there's a fundamental aspect to the provisions, whether they're in a precinct or in an overlay, that is not solely the consideration of character elements for new development. The driving factor of these character precincts comes from the protection of the existing housing stock, which derives the character that's sought to be protected. So, and put another way, if we are to consider the character contribution of a new development, that is in itself fine, but that is a general amenity type matter rather than seeking to consider character with reference to the existing housing stock from which that character is derived. Yeah, that might be a bit clearer than my first attempt.
Can you say it again? So I was going around in slow circle trying to.
Just before you do, I guess the question is, in the event, or if we were of a mind to extend the HRZ as requested by Kaingaora to a wider walkable catchment,
Yes.
and in doing so that intersected with a character precinct, would that mean that the character precinct is jettisoned, or would you keep it as a as and rename it as an overlay. I think that was the sort of question.
Yeah,
You couldn't, there's nothing to preclude duplicating the precincts
In both zones.
in both zones.
Yes.
Because we already have situations where character precincts interface with existing HRZ. So if that HRZ was to expand, there's nothing to preclude that interface issue existing elsewhere.
But this is more than an interface.
I know you're talking about it. Yeah. But equally, there's nothing to preclude the equivalent character precinct provisions as they currently stand being moved into the HRZ.
Yeah.
I would probably want to think about whether that would tip it into an overlay. Yes, but I don't immediately see why it couldn't stay as a precinct either. It's still, the provisions would still apply to a singular, a singular zone in that chapter.
The key difference being a lower height in the precinct.
Absolutely, and that goes to a different matter of, is of appropriateness of that level of development.
Just for, sorry.
that just following up the logic of that, given we only have 3 residential zones and one's very much on the periphery where clearly none of these character areas apply anyway. There are sort of like the distinction you've drawn, say, the logic you started with was, well, precinct is for one zone, district-wide rule for multiple zones. Well, there aren't that many zones to be like one is effectively multiple, because
there's a further element of that sort of goes to support precinct approach, which is that it contains everything in one chapter. So from a workability, operability, ease of use perspective, then it probably also favours a precinct approach.
and I suppose is heritage a precinct? Is it an overlay?
I think it's an overlay, sir.
To be an overlay by definition.
Yeah, exactly.
And sort of given the overlap between the character and heritage, I understand they're not the same thing. You explained that, but because of the overlap, if the idea is clarity and ease of use, you're on the slippery slope. It's sort of trying to say, well, character is so intrinsically different, it needs a precinct, but heritage is a district-wide rule.
Well, I think the distinction there is heritage would clearly span whether it's city centre zone, a local centre zone, a residential zone, an open space zone. That is probably what very squarely tips it into an overlay.
Mr. Lewandowski, the scenario I gave you about giving effect to the Kaiangaroa submission, extending the HRZ, and what happens where that intersects with an identified character area. Does that, and this might be something for Mr. Patterson too, does that raise, well, I guess with consideration there is not only how that intersection is dealt with, but what is the best zoning for that area? I mean,
for the underlying, for the character precinct.
Yes.
Area. Yeah. Well, that also speaks to, do you move the precinct or not? Because
yes,
if you're extending the HRZ zone and you're intersecting with a proposed character precinct, there's a parallel question here of, does the precinct, if you like, survive this process or not?
That's why I used the word jettisoned.
Sorry, yes, quite.
Yeah.
So, I mean, I would accept, sir, that if your ultimate finding is that the character precincts are jettisoned.
So what was the last word? If they are
jettisoned, to use Mr. Takashi McMahon's word, then, and this is a question for Mr. Patterson, but the appropriate zoning, I would agree, is as per a broader, if you like, consistent approach to how you have set out walking
Yes,
catchments,
and
etc.
the two options are MRZ or HRZ.
Correct. So that's a separate question to
Yes.
the merits or otherwise of the character.
MRZ with a height area. Yes, if there's if there's a good reason to depart from the HRZ, but no good reason to go to a baseline MRZ.
Yes. And I would just simply point to Mr. Patterson. I haven't thought that far.
I mean, this is gonna apply to areas like Mount Victoria and Thorndon, I guess.
Yeah, Mount Cook to an extent, Arrow Valley to an extent. I think the only one that, or Newtown, perhaps the one that would probably escape that consideration largely would be Berhampore. I stand to be corrected on that, but I think it's probably sufficiently outlined. There's a public transport aspect to Berhampore.
Okay. Can that be HTZ too?
Can I just ask a question that actually relates to that? When we are saying, oh yeah, we might actually have to take the HRZ into the precinct, could we bring that in because of walkable catchments and other issues? Is there a logic behind that saying if it's a character precinct, a higher residential height would by no means be appropriate? It feels to me quite theoretical to say we could have more height in character zones, theoretically, if there is a walkable catchment or whatever, but what does that do to the character of the precinct? And is that just sensible? Is that logical? Or are we just talking a theoretical point of planning, which I might not understand?
It might be a little bit of all of the above. And this might go to a more fundamental approach here, and that is that in terms of the character precincts, the Mount Victoria North is slightly different. In terms of the character precincts, there are two fundamental controls that are different. One is a control on demolition, and the other is a control on new development. When new development is concerned, notwithstanding that it's a restricted discretionary from the start, the standards that have been applied are those of the MDRS. So we have lined up squarely with, well, squarely not quite. There are two minor variations to it, but fundamentally those line up. I took Commissioner McMahon before through the existing height standards that apply to the inner residential area. And whilst there was some variation there, the variations sort of range from 8 to 11 roughly. Yeah. So what we've got now is effectively an 11-metre uniform. So there is a reasonable consistency, if you like, from the operative to the proposed, albeit there's a slightly increasing trajectory from the bottom end of 8 to the higher end of 11. Over and above that, there is no preclusion for a higher height limit. It's just that there is an additional resource consent trigger. So I'm not sure if that answers your question squarely, but I think yeah. So yeah, there may be instances site specific where 14 could well be appropriate, but the fundamental contention is that that's appropriately assessed through a resource consent process with reference to those character values.
And is the logic of using the MDRS as the base, aside from the fact that you then have to justify fewer shifts from the MDRS, that it's, as you say, the ODP was 7 0.5 in Aria Valley, 8 in other places. It's not a colossal difference.
I think there's a few things there, Commissioner Robinson, and there's not a colossal difference. There's a lot to be said for standardisation. But importantly, sir, it is actually also a very strong nod to the fact that the MDRS standards are there, the NPSUD is there, and whilst I recognise that we're proposing qualifying matters that restrict that, restrict a permitted, importantly, a permitted level of development, and the permitted is important because of the demolition aspect. We are nevertheless still seeking to provide for some development capacity in that area, and I think that that's a very central point that shouldn't get lost, because there's a lot of, I think, back and forth about the extent to which these things give effect to the NPSUD and MDRS, but they do give effect to it at least some of the way. It's not, you know, we aren't creating museum pieces of these character areas. We're seeking to provide some development capacity, albeit for a process.
And would you say that because we had submitters that said, you know, no, we can't have any height above and beyond what was already there, which of course is mainly 1 and 2 stories. The MR set is actually the 11 meters and slightly higher. And therefore, I understand there is more capacity, of course, having at least, you know, than 3 stories. Is that sufficient increase in those areas? And we know that these areas are not all over the place, they are just confined to certain spots. Is that sufficient increase that would actually make you comfortable with saying this actually works with the NPSUD and it works with the MDRS, so that in terms of the amount that you could actually do, that zoning is actually enough as a step above of what we have now?
I think I might have lost you partway through, Commissioner. I'm sorry. I think I get the gist, and that is that the increase from current to MDRS gets us further down the NPSUD road. Is that what the question was?
Yeah.
Then I agree with that, yes.
Then coming back to your point, not creating museum pieces, is that the important difference between a character area and a heritage area, that there's a much stronger policy direction for those items that are identified as actual heritage, a much stronger policy direction on restriction of development than there is for the character area?
I think that's fair, sir. I wouldn't, though, want to undersell the starting point in character precincts. It's not simply a matter of apply and it shall be demolished. There is still a policy hurdle to reach, but certainly they are a different policy. There is a different policy environment across those two, and I think as a general statement, the heritage is a higher standard. Just to add there, the character considerations also relate to the condition, quality, etc. of the building, and there is a little bit of change there from the operative plan. There was a much stronger linkage between an entertaining demolition without reference to a replacement proposal. We forced to split that up here, so you can consider, you can come forward with a demolition proposal without reference to a replacement proposal, and in the character precincts in the proposed plan.
What is that?
Cost and risk. So if you wanted to entertain a demolition proposal currently, you would have to have a reasonably high level of investment in preparing a replacement proposal. Now, if you've got a reasonably high level of uncertainty on the potential outcome for your resource consent, then you might be reluctant to be spending not an insignificant amount of money developing a replacement proposal. There was one slightly interesting example on, I think, Grant Road, served from memory, where an applicant was consented for demolition. There was quite a sort of intricate set of conditions that effectively precluded the exercise of the demolition consent until such a time as the new proposal was considered. But I think that was an oddity or a rarity that I found in looking at the background to some of this topic.
Effectively a condition precedent,
Yes.
probably precisely what it was. That was, the logic of that was to get over the point that you've identified.
Of the linkage between before you demolish, you must have a consent. You must have an appropriate scheme to replace. I think in my example, so there might also have been some time frames around it as well.
Gentlemen, so is that your summary?
Not at all, sir. I'm
We haven't got quite
not sure where I
summary yet.
was and where we departed, but I was trying to sort of, I think, paint a picture of how the chapter works, and we started off with precincts and meandered perhaps a little bit. I can carry on through that structure.
Karen, I'm just looking at the clock thinking that some of us need a cup of tea.
I'm in your hands, sir.
Our scheduled time is only 5 or 6 minutes, so is it useful for you to carry on, or should we stop now?
I don't think I can get done in 5 minutes, probably.
Let's break down and come back for you at the conclusion of the summary. Thank you. So we'll break and we'll be back at 10 to 11.
know we've gone. I can start. On what, if you're happy to start now, on what matters you were just discussing before the break. I was speaking with Mr. Lewandowski, and I had a reflection that he thought I should share with you. I don't know whether I'm just repeating what you've all just said or whether it's a slightly different way of coming at the issue. What you were discussing, it seemed to me, were the substance of the MRZ versus the HRZ as the underlying zone, whereas I see the issue as almost more of one about the process of your decision making. What's the logical sequence in which you apply the legislation and the NPS? So to me, the first question is there an established qualifying matter? Are you satisfied of the evidence supporting that qualifying matter? And if the answer to that is no, then whether it's MRZ or HRZ will largely, if not entirely, be dictated by application of the NPSUD Policy 3, and it will probably be, perhaps there's an issue about Burrampore, but it will probably be HRZ because it will all be within a walkable catchment of the town of the city centre. If the answer is yes, the qualifying matter is established, then the question becomes, what is the least restriction necessary on development that is compatible or commensurate or appropriate in light of that qualifying matter? And that's the approach that the council has taken. And there's a couple of paragraphs I can take you to when I end up responding to the first legal question asked this morning from Mr. Lewandowski's supplementary report, where he talks about that in response to the submission of Kainga order about the HRZ versus the MRZ.
The interesting thing, Mr. Wellington, is that I can understand that if the effect of the qualifying matter was to downzone the area subject to the qualifying matter, but if you have a precinct over the top, it's more of like a designation scenario where the historic approach was always you had an underlying zone for activities not within the designation or in case the designation got uplifted. But like a precinct seems to operate the same way as a designation, right? Because it doesn't modify the zone provisions, it just it comes in over the top and has a different set of zone provisions.
Well, I might have to get into the national planning standards just to check the way in which that they discuss precincts, but my understanding of a precinct is that it's not quite the same as a designation. It applies, it sits within a zone, so you have your zone rules, but within the precinct, the zone rules don't apply, the precinct rules apply. And the reason that it's located within the zone is that that's the most logical place to put it within the plan.
Yes. Well, conversely, with an overlay, both rules apply, and you trigger both rules in a bundling approach.
That's right.
Yes. Okay.
So my analogy is wrong because the precinct operates in effect to create a subset within which the what you might call the underlying or overlying whatever zone doesn't apply.
Yes, that's right. That's my understanding, but as I say, I'll have to go back to the national planning standards to just confirm that.
Yes, the key thing is here, was there the intent?
I'm about to cover that exact issue next. Right.
So that's all I was going to say on that. That I saw it as, or I thought it might be helpful to try and put it within the sequence of steps in your decision making that you will approach it. And my understanding, Mr. Lewandowski will no doubt explain it, is that his position is that if you start from the other zone, the zoning that you might otherwise apply, which is HRZ, that is simply incompatible with the character precinct, and therefore the appropriate level of development that is still intended to be enabled to some degree is medium density zoning, because that can be applied in a way, it can enable some intensification in a way that nonetheless remains compatible with the character.
Another way to look at it is, say, where the character area doesn't apply and it's still within a walkable catchment of the city centre zone, for instance, then 3C would suggest wire that it be HRZ. And if you have for Mount Vic, for instance, character areas with HRZ below it and HRZ below above it, it would seem rather odd that that the precinct sits solely within the MRZ. It's just an impression I had. Like, I can understand why you've taken your cue from the MDRS rules, because ultimately that reduces, at a purely practical level, that it reduces the changes you have to justify.
Yes. I mean, the other way of thinking about it is, though, that what you're trying to do is set the appropriate trigger for height, for example, for a permitted level, as opposed to where a consent is required. And Mr. Lewandowski's position, as I understand it, is that the appropriate height trigger, or the 11-metre height trigger, is not to say that in the character precincts a development can't be allowed of higher than 11 metres and you can't go up to 14 or 16 or 18 metres. It may well be that in a case-by-case basis, there are some developments that can be done at that height which are nonetheless consistent with the character values. And so it may be allowed, but it's allowed through a resource consent rather than being set at this stage in the plan.
Corollary to Lewandowski's questioning and your explanation, if it's truly a subset, it doesn't actually matter which chapter it's sitting in, because it's a standalone set of controls, the geographical area, the subject of the precinct.
That's right. You could call it the character zone, and you've got a MRZ that sits, an MRZ zone that's, or HRZ zone that sits around it, which might look a little odd on the maps, but you could do that, I think. And again, the national planning standards have guidance about when it is appropriate to create a zone as opposed to using a precinct.
I've just got a mechanical question following that, and it's to Mr. Lewandowski. I wrote down that the entry level and the character areas is RDA development. Is that correct?
You do correct. Yes.
Yes. And that's for both demolition and development.
Correct.
Yeah. And is the development one, is the development RDA status predicated on 11-metre height?
Correct.
So if you exceed 11 metres, you're no longer an RDA.
You're still an RDA, but you're an additional RDA. If you like, there's a separate consent trigger for that breach.
Oh. Okay.
But
Does that work?
presumably an additional policy direction around that.
So it's not a true precondition to being an RDA, 11 metres.
I'm just going to go double check.
Yeah, you understand what I'm.
I do understand.
It doesn't default.
It doesn't
to higher
take you
levels,
into a
so-
higher activity status.
Doesn't.
No, it doesn't.
Okay. There's examples of that in the operative plan with the central city zone, I think, too, in relation to height and bulk.
No, sorry, I apologise. It's RDA, that is correct. There is one rule, and within the matters of discretion, the extent and effect of non-compliance with any of the standards is a matter of discretion. So it's self-contained rather than rather than an additional one creeping in. I'm sorry about that.
So what is that? What's the one rule?
MRZ precinct 01 R5 is the new development rule.
What does it basically say?
So that is for the construction, addition or alteration of any building or structure, excluding accessory buildings.
Yep.
The matters of discretion are the extent and effect of non-compliance with any of the standards that are specified in there.
Yeah, so standard one is height, is standard one height,
Correct.
and that's 11 metres.
Correct. Okay. And then the others, there are 3 other matters of discretion. Second lists the 3 policies. Third is a residential design guide appendix. And the 4th is applicable to multi-unit housing.
Thank you.
Just going to ask you, I think that diversion, you should fire into your
Yes.
summary.
Sarah, where we left, I was taking you through the structure of the chapter as it relates to the 2 precincts I'm interested in. Picking up on a point just made around the relationship between the MRZ and the precinct chapters. The introductory statement to both the character precinct and the Mount Victoria North precinct says that the land use activity rules for the MRZ apply to the character precincts. The building and structure activity rules for the MRZ do not apply to the character precincts. There are separate building and structure activity rules that apply within the character precincts. There is an equivalent statement for the Mount Victoria North. What that means in practice is that we have a singular chapter. There are provisions that are additional to the 2 precincts, and there are provisions of the MRZ that also apply to the precincts. And so the distinction is made within the chapter as to what applies and what doesn't. So for instance, if I was to propose a retirement village within the character precincts, there is no specific retirement village rule applicable within the precinct provisions, but there is a retirement village rule within the MRZ provisions. That is the rule that applies. Yeah, it provides for that land use activity, as I believe restricted discretionary, I think. Clearly, the construction of a retirement village is subject to the building and structure rules of the precinct itself. I don't propose to take you through the minutiae of the particular objectives and policies. There are specific ones there that are applicable. Perhaps drawing on the somewhat covered already, but in terms of the character precincts, there are 2 key rules there. One controls the demolition, that is rule R3, precinct 01 R3, and then there is the new development rule, which is precinct 01 R5. There is a little bit of permitted activity. Accessory buildings can be built as a permitted activity subject to standards. Demolition of things not pre-1930 is a permitted activity. There's a recommendation in the 42A to provide a little bit more clarity around that. Fences and walls, again, permitted activity subject to a standard. We talked earlier about the MDRS standards being effectively adopted. There are 2 variations there. One is to the height of accessory buildings, which is capped at 3.5 metres. The other is to fences along the front boundary, which is capped at 1 metre, as distinct to the MDRS standards.
What are the MDRS standards in both of those situations?
Yeah, it's 2 metres for fencing. The MDRS height is universal, as I understand it, so it would be 11 metres. I don't believe
For accessory buildings?
I don't believe there's a separate line for accessory buildings in the MDRS. I think it's universal.
You capped it, did you say 11.5 or no, 3.5?
3.5 for accessory buildings. And 1.
Verse 2.
Correct. Both of those are responses to streetscape effects. You would have seen that come through the section 32, particularly in terms of the examination of older consents, and some of the issues that were arising were accessory buildings, if you like, constructed in that intervening space, front boundary and building elevation, and also height fences. Because what we're really that character is often evident from the streetscape. So you'll see a streetscape approach is driven in the policies that underpin this. And so 2 metre high fencing is clearly a reasonably obstructive element in that streetscape. So that's where that control is departing, and why that control is departing from the MDRS.
And as you say, 3.5 metre high garage in the front yard would be typical of something that was built post 1930.
Yes, and that standard, there was some work done by the council around that standard in a different context, and that escapes me a little bit, but there was quite a bit of work done to try and figure out what is a practical and appropriate height for a garage. You clearly can't set a standard for a garage building that is just going to be triggering a resource consent at every single instance, because a regular garage is breaching that. So there was work done to ensure that was a viable. Yeah, exactly. Jumping to Mount Victoria, North Townscape Precinct, there is note a large overlap in the spatial extent of the Mount Victoria North Precinct and a character precinct. So there's a degree of not duplication because they're dealing with different matters, but there's a degree of overlap between them. The key distinction between the 2 precincts is that the Mount Victoria North Precinct doesn't have a demolition restriction within it. Where it overlaps, of course it does, but where it's distinct, there is no demolition control. What we're interested in there in the characteristic of that townscape is its visual element, and I'm sure you're all familiar with that view whether from the waterfront, etc., towards St. Gerard's and that surrounding escarpment. So that is the characteristic that's identified in a spatial sense of trying to capture, if you like, that view, albeit in a plan view rather than an elevational sense in how that's mapped. Again, the approach is that building and structural rules are distinct to the precinct, land use rules are within the zone chapter, and there are no specific standards distinct to the MDRS that apply to the Mount Victoria.
And the other thing is that while they're all part of that common view, there are some pretty ordinary monolithic apartment blocks don't obstruct the view of St. Gerard's, but are like on either side of Oriental Terrace.
Yes, and I think
and up behind the Seven Sisters.
Yes, and those would be captured by the Oriental Bay Height Precinct.
Yeah,
distinct to the Mount Vic North.
But the point being, it wouldn't be the end of the world if they were demolished.
I wouldn't express a view, sir, but
from a planning perspective. Understand.
You may get onto this, Mr. Lewandowski, and tell me if you are. I'm just wondering about the demolition of pre-1930s buildings and the rule framework for that. Is that? I mean, there was a rule in the operative district plan on that. I think it was focused around streetscape issues, but the way it's applied here is it does it only apply where it's in a character area, as opposed to a global rule across the residential zones?
Well, it was only a global rule, Commissioner McMahon, in the operative plan in the identified in the residential areas. Now, those areas were wider. It didn't apply in the outer areas, for instance.
Yes.
So the approach is fundamentally the same, but the area of application is much smaller.
So in the operative plan applied to the inner residential zone only, and within areas specifically identified within that zone.
Correct.
And you're saying that's the same approach in the proposed plan. It applies in identified character precinct.
Correct.
But they are smaller than the operative district.
Correct. Yeah, and I will take you through those changes in the area soon. Well, in fact, I'll do that now, perhaps, before I move away from the plan and move into a more of the statutory context. The operative plan identifies what are called character areas currently. You've got those in the maps that were appended to my report, and you've got those in two different sets. Do you need the appendix reference, commissioners, or have you got that to hand?
Useful to have it.
So there's two, it's appendix 1 to part 4.
Yes.
And then appendix 2 to part 4. The appendix 1 to part 4, Commissioner McMahon hits upon the question you've just asked, and on each of those maps you've got two panels. The panel on the left shows the operative district plan character areas, and so that is the area where the existing demolition rule applies. The panel on the right shows in pink outline the character precincts proposed as per the notified plan.
Yes. And
the areas in the darker blue or purple are the additions recommended by the 42A report.
Yes.
So that answers, I think, Commissioner McMahon, your question
Yes.
around the extent of the application.
I just don't have those maps in front of me, but I've made the notations and I'll look at those later.
Sure. That is probably my overview of the district plan element. Happy to take questions on that now, or I'm happy to move on to the statutory sort of basis for these.
I think we'll pick up questions on the detail
Understood.
as we go through the report. Thanks.
Clearly, as already traversed, we're proposing these areas as a qualifying matter. The basis for that lies in section 77I subsection J. And just to acknowledge that that is a discretionary element, there is no directive for that to occur. So the council considered, I guess, advice from officers at the time that they did want to proceed with some form of character protection, and that resulted in the notified plan. Commissioner McMahon, you asked earlier about the draft spatial plan, and I'm sorry to come back to it, but just to sort of close that out, where I talked about the character approach, and you asked a question around that, and I've just gone back and refreshed my memory. How that was framed in the draft spatial plan was that the character precincts as proposed in the plan were identified, but the overall extent of the operative character areas was also identified. And what that draft spatial plan suggested was that demolition controls would still apply within the character precincts, but that the balance of the existing character areas would look to consider character, would not have demolition controls, but would still have a control for new development with reference to character considerations. Now, that wasn't ultimately pursued. I think part of the answer for that was seen as a additional regulatory hurdle to MGRS and MPSUD. If you're not protecting the character fundamentally, why go through a token resource consent? Not necessarily token, sorry, that's the wrong word, but why go through a resource consent process on general amenity matters where district plan parameters can control that? I just wanted to close that loop, sir, because
Yes.
I left that.
And the reason for that was the difference in the spatial extent between character areas and character precincts.
Yeah, so it sort of said, well, we've identified these areas currently, we're refining them down for where demolition controls would apply,
Yes.
but let's still sort of give a nod to character outcomes within the balance. But as I say, that ultimately was not pursued. So having considered section 77I, that is the opportunity, if you like, to present these. The next stop is section 77J, and what that requires is demonstration of why the TA considers that an area is subject to a qualifying matter. I think I've covered that off in the various reports you've got, but clearly character consideration and character being a defining element of the character precincts. And with respect to Mount Victoria North, it is the townscape significance of the area identified. And then the qualifying matter being incompatible with the level of development, and importantly, I think I talked about before, permitted by the MDRS or as provided for by policy 3. And it's that permitted element that is a key consideration in providing for those character demolition controls and new building controls. Assessing the impact of limiting development capacity, that is the work that's being done by property economics, both in support of the section 32 report, and then the supplementary that has been done with respect to the additional areas recommended.
That was the one in November last year, wasn't it?
November last year was the first instance one, Josh, that's correct. And then accompanying my 42A report is the supplementary.
I got you.
And then just to highlight there, that is the assessment of limiting development capacity, building height or density. Clearly, there's obviously the three elements there. The development capacity, I guess, is limited in the sense of the demolition preclusion. The building height is increased from operative, but limited to what it might be in the absence of these, where a high density zoning would apply. And the density limitation, in my view, doesn't exist in the sense that there is no particular preclusion on density. It's preclusion on, sorry, preclusion. It's a resource consent requirement for new development. There isn't a density standard that goes hand in hand with it. Assessment of the costs and broader impacts. That has been done in the section 32, and then that's been elaborated on in the 42A and my supplementary. There's been a line of argument or criticism from KO in particular that there wasn't an explicit consideration of a high density option. One of the options that was considered was a removal of the precincts. Now it follows, in my view, that were they to be removed, clearly there is and it was identified as such, a need to upzone in line with MDRS and policy 3. So simply highlight that as whilst it wasn't necessarily considered under a distinct heading of high density option, that consideration was nevertheless made. And the last aspect of 77J is a consideration of how the MDRS is modified, and I've just taken you through the modifications that have been made in respect of these areas.
One of the things those statutory requirements require is a consideration of costs and benefits against the national significance of urban development. And so it's not costs and benefits in a vacuum.
Yes, the wording in 77J is assess the costs and broader impacts of imposing those limits. The national, I'm ultimately going to defer to Mr. Wellington here. The national significance language comes in at 77L subsection B. But they all point towards the section 32 evaluation. I agree with that, sir.
So it justifies why their characteristics make that level of development appropriate in light of the national significance of that in the urban development and the objectives of the UPS correct UD. So where's that?
Where's that assessment?
Yeah.
Well, sir, I guess I set that out in my section 32 evaluations and my supplementary evidence, trying to draw all that together. Again, you won't find a specific subheading called section 77 LB. What's being done though is an identification of those characteristics and a response to how the plan gives effect to NDRS standards and policy 3. We've got a situation where we've reviewed the existing character areas and substantially knocked them back. Where those areas have been knocked back, MDRS and policy 3 has been applied. And so that is absolutely an acknowledgement of the national significance of urban development and how that's been responded to in light of the characteristics of these areas, which leads to their identification as qualifying matters.
I suppose the issue in terms of the evaluation is it's a glass half full, half empty. Is the reduction from the ODP the focus, or is it the increase from nil restriction?
Well, the starting point I acknowledge is nil. Yeah, that was my starting point. These are a discretionary element. There is no compulsion for them. So the starting point absolutely is nil. With that said, because they are an existing element, the job was to consider whether they remained a valid element. And so you've got two assessments that support that identification. But then also, do they remain valid as they currently stand? The answer there, particularly in light of the character precincts, is no. So that has led to a significant reduction. And then, do they still meet the threshold as a qualifying matter? Now, in my view, sir, they do.
Obviously, there are a number of people who we will hear from who disagree with you.
No.
It would be useful, Mr. Lewandowski, if I'm looking at your paragraph 106.
42A, sir?
Yes, yeah, page 19. You take us through some key areas there. You also talked about the tests in clause J, and I can't remember where you outlined those. That was on paragraph 38, page 7.
Yes.
I wonder whether you could provide the panel with, I'm going to use the word roadmap, that links A, B, and C, and under J to the section 32, to the 42A, and to your supplementary.
Yes.
So that when we're considering A, B, and C, we can go to the relevant paragraphs in those three documents.
Yes.
Just it's solely mechanical. Could you do that?
Certainly, sir. And
Like
no, I appreciate. Yeah, and I appreciate that.
I'm thinking of a one-page table.
Yes. A tabular format would be useful.
That, in terms of what I've been asked to do, the legal question 1.
I think that might have just been overtaken.
Well, that's right. So I have prepared, at least by reference to the supplementary report, the particular paragraphs that I was going to take you to and show how they fitted in within A, B, and C, and 77J and 77L. I haven't done that yet for the 32 or the 42A, but that was my next step over the lunch break and things like that. I think the table sounds like a much better way to do it. I'd still like to provide a bit of explanatory.
My question would be, are you going to be to have the pleasure of your company tomorrow?
Yes.
I wonder if it's not too much of an imposition to ask between you and Mr. Lewandowski if you could produce the table tonight, and then we could talk. You could run us through it with us. You having the table as a reference point. Is that possible?
Yes,
I think so.
I think so.
And presumably that'll refer to Mr. Osborne's reports, etc. too. Yeah.
Yes.
And yes, and I guess the Boffa School report.
Yes, and the Urban Perspectives report and
Yes.
Mount Victoria also.
Yes.
The Boffa School report, that's the 1930s,
Yeah.
pre-1930s
Yeah.
character assessment.
I assumed that's what it was.
Yeah, no, I'm just confirming
Yeah.
that I'm thinking of the same.
Yeah,
same
absolutely.
report.
Yeah.
I think that's all good.
Thank you. I think maybe the rest of what I was going to say might have just been overtaken by events, but I don't think there's any dispute that the site-specific identification hasn't occurred, that the specific characteristics on a site-specific basis haven't occurred. And I've talked to some of those options already in terms of 77LC3. So we can cover that off in the material we're providing for you tomorrow.
And Mr. Whittington would have heard this question in the prior context. There's some overlap between the legislation and the NPSUG. I mean, we're talking about 77L here. I think the equivalent provision in the NPSUD is 3.33.
Yes.
Yes. And I think it's the second part of that that relates to the discretionary qualifying matters, and it sets out a 4-step process, including site-specific analysis. So it may be, to the extent that that's relevant, that might be the basis for the table.
Yes, I haven't looked at that NPS one for a while, Christian, but my recollection is that they were very, very similar.
Yeah.
The advice we had on the parallel context was that they were practically identical, and to the extent there is a difference, it was not a material difference.
Yes. Just that when I read your paragraph 38 summarising 77J, I'm just not seeing the terms site-specific analysis. I don't have the NPS in front of me. Pretty sure it's 333 by memory. Yeah.
333.
So there's not a qualifying matter under 332, and it's H in the NPSUD, whereas J in section 77. In relation, unless an evaluation report identifies, and then it's got identifies a specific characteristics to make it a development. So how does it get in the tent?
Yes.
And it includes a site-specific analysis that identifies the site to which the matter relates, evaluates the characteristics on a site-specific basis, and then evaluates the appropriate range of options to achieve the greatest heights and densities as directed by policy 3 while managing the specific characteristics.
Yes. Just in terms of your comment around paragraph 38, section 77J doesn't bring in that site-specific language.
No,
that comes in at L.
Sorry, L. Yes. Yes, and that's paragraph 39, isn't it? You're dealing with that. Yeah. Well, I'll leave that to you, Mr. Whittington,
Yes,
as to how that's best presented in the tabular format.
So I'll leave, I guess, the statutory environment now, and just to sort of wrap up, submissions on the character precincts were primarily, well, there were probably 3 points of focus. The use of the qualifying matter, which we've just traversed. There was a number of submissions, both in support and in opposition to the Boffa School pre-1930s assessment. And then the fundamental bulk of submissions really address the spatial application. So 2 extremes there, I guess, 0 or current operative extent, and a number in the middle that supported the what is actually ultimately proposed now, the final spatial plan recommendation. And then a subset of submissions that addressed the spatial extent at a more site or street or neighbourhood specific. So rather than a greater at a greater scale.
Basically, they're geographically focused. In terms of things we might ask you to do, I had in mind asking you. You have given us ODP, well, in the Appendix 1, it's ODP versus notified. You've recommended notified be extended. I was reading the Mount Vic Historical Society have asked for another 104 sites. Would it be an imposition to ask you in Mount Vic if you could identify on, in relation to your recommended character areas, where those 104 sites, what the effect of accepting that submission would be? Because I was going to ask you to talk me through your views on that request, and then it'll also assist if we, when we hear from the Historical Society, if we have a map in front of us, rather than they've given us street numbers and photos of the houses, but that gives me no comprehension. Like I can see that there are gaps. Some of them are continuous on one side of the road, on one side of a road, but it says, is that possible?
I think so, sir. Has that come through their
Presentation.
submit a presentation? I haven't seen that yet, sir. So that's why I ask.
Well, that's probably a good idea, since I'm now telling you I'm going to ask you questions about it. If you do have a look at it.
Yeah. So you would like, just to be clear, you would like those properties contrasted on a map
That shows your
that
recommended.
shows the recommended areas to see which of those are picked up and which might not be.
I presume that they're all additional, but they may not be. And it doesn't have to be a work of art.
No, I understand that. I'm thinking a reasonably coarse GIS assessment, which will be relatively straightforward. It's going to be pulling those into a list and then overlaying with the map.
And say the Mount Vic Society's presentation has all the numbers tabulated, numbers and addresses tabulated, and photos. So it's perfectly clear what it's talking about. It just gives you no spatial understanding of what the end result is.
Yes, I'm looking at it right now.
Thank you.
That's doable, I think, sir, absolutely.
That would be helpful. Thank you.
In terms of the key recommendations, just to wrap up, the principal change is to the spatial extent of the character precinct. Now, the fundamental driver of that is what I consider to be the mapping as notified, not appropriately achieving the objective for the precinct. And the objective for the precinct is MRZ, precinct 01, objective 1, which outlines the purpose. And hand in hand with that purpose is the definition of character. I won't take you through that definition completely, but it talks about the concentration of common consistent features and characteristics collectively combining, etc., etc. When you consider that objective in line with that definition and the Miskel report that has informed that mapping as a starting point, and the reason I gave you two sets of maps there, the second set being the character contributions on a specific basis, you see, I think, quite plainly that there are large areas of sort of consistent character, i.e. concentrations of primary and contributory buildings that were not picked up first instance. That has been the driver to the recommended increase. I've also acknowledged in the 42A for commissioners, and I'll acknowledge again now, I'm sure that there are a number of ways that the boundaries of these properties, of these precincts rather, can be crafted. What my evidence suggests is that we have a documented methodology that was applied in a consistent way across these areas by a group of people, a group of staff of the council. And I consider the boundaries that are proposed to be rigorous with reference to that methodology. Acknowledge that others could come at it in a different way and come up with similar, slightly different, or quite different boundaries. I note that there's Heritage New Zealand, for instance, has expressed a level of comfort with the boundaries as proposed.
So sorry, just on that, you have said though that the methodology was refined in between the notified and your section 42. I just wondered what that meant. So that's at 87, your para 87, you're saying that you have refined the methodology.
Yeah. I can speak to that somewhat, Commissioner Burge, but the areas that were originally identified, I wasn't party to. So I'm not 100% sure on that methodology. They certainly looked at the indicative areas from the BOFA report. They overlaid those with the what are called sub areas in the operative plan and design guides. And from that, some boundaries were drawn. We sort of went back to square one somewhat. Said, all right, well, that was the starting point. Let's have a look. Let's have a look at all these concentrations that are missing, and let's put some parameters around this methodology. So we looked at the streetscape approach and both sides of the street, etc. That's documented in, I think, another appendix there for you. How do we approach situations where there's open space on another side of the road? How do we deal with topography, etc., etc.? So it didn't generally result in any removal of previously identified areas. It certainly picked up a number of additions based on that criteria. So it really was a sort of a kicking the tires type situation on that existing methodology, and really structuring a methodology and preparing for that spatial plan recommendation. And so we revisited that for this week.
Mr. Lewandowski, maybe Mr. Wellington, as I understand that you have included areas which are identified as not actually contributing to the character in order to achieve a more cohesive overall area, that I understand your approach correctly. The question for you in terms of the section 77L test, which requires a site-by-site analysis, you've clearly undertaken the analysis, found that it doesn't contribute. Is it then consistent with the section to say, notwithstanding that it doesn't contribute, you're still going to make it the subject of the qualifying matter?
So it's about the questions about the strictness of the approach. I don't think there can be any doubt that the council has
you clearly
done site-by-site analysis.
but it's what it's done with the assessment.
Does the law require effectively each, or this precinct? It probably wouldn't be a precinct that you would use, but do you have to go through and say the following 1, 3, 7 and 9 Marshbank Street and only apply it to those houses which contribute principally, as the word is primary or contributing. Primary are primary character buildings or contributing character buildings, and you distinguish them. In any other building, it just doesn't apply to you. You have the underlying zone, and well, that's fundamentally a legal question as to what the law means by site.
That's why I suggest that you might be able to assist on this, because I'm aware that this is being fought out in the Auckland context.
Yes.
As a contested legal issue.
Yes. Well, I might add that to my things to think about tonight.
We're not getting much sleep tonight, Mr. Whittington.
I mean, my approach is it's not practicable to do that, and it won't maintain the character of these houses that are intended to be protected to some extent if all around them 18-metre tall buildings are being constructed. So there's an argument that even the non-contributing buildings nonetheless have to have the precinct applied to them, so because it is compatible with the character values or with the qualifying matter, or it would be incompatible not to do so. But I'll have to go through the specific statutory wording.
The Commission answers right across the Auckland issue, of course.
And I think that distinction between can we leave it in and it is just there, or what you just pointed out, what is incompatible. Make that clear. If it can be left there because it fits with the overall character, and how incompatible would it be to take it out?
Yes.
And and I think also what would the effect that would have on the character and on the precinct, because what defines a precinct? Is a precinct an empty tooth?
Well, that's the question.
Mouthful, or
the definition of, or the purpose of the zone that Mr. Lewandowski just referred to was what's the defining characteristic that's being used to justify the qualifying matter is concentrations of buildings that contribute to a character or a particular amenity, and it's the concentrations of buildings. So if you have so the question then becomes a much more contestable one about where do you draw the boundaries around the concentrations, and if there is a building a little further away, does that is with some non-contributing buildings in between it, do you draw around the building or do you exclude it? That's a very difficult.
The analogy might be drawn with the authorities on O&Ls, where it's been the law for a long time that you can have the occasional non-contributory element.
That's right.
Disquieting element in the middle of a landscape. But that's prior, so long as it doesn't stick out so much as to degrade the entire landscape, it's still within the O&L. You don't draw a hole in the O&L.
No, that's right.
But of course, that doesn't have I was going to say statutory, it's not statutory, but a higher order direction to consider
site by site.
Consider on a site by site basis.
That's
so
right.
The question is that, well, clearly it has been considered, but is the analogy useful?
Yeah.
It is.
Just to pick up on that point, and while the conversation's been going, I've been scrolling through the character contribution maps. It is very rare, though there are some instances where there are some detractive properties within the recommended areas, but they are very, very rare. And that reflects the way that these areas have been crafted. There's some that that are inescapable because you're still trying to create a logical boundary. Slightly more so for neutral, but the overwhelming contribution is primary or contributory. The other thing I would say, particularly around the detractive, is that their condition, their contribution speaks to the policy approach for demolition. So a building of greater originality and higher character contribution, the policy framework would be harder to obtain. It would be harder to obtain a resource consent for its demolition as compared to a detractive building. Building condition in terms of its physical state also speaks to that, and the two, I suspect, are often related, resulting in repair and maintenance and etc. So that would be the additional sort of factor in that discussion, and how they are ultimately treated within the regulatory parameters.
Mr. Lewandowski, is there a particular policy that you'd reference to assist in that analysis?
So it's the Precinct 01 policy P2.
P2.
And it's the first matter in that policy. It talks about whether it can be demonstrated that the contribution of the building to the character of the area is low, with reference to its level of visibility, whether the building is consistent in form and style, that contribute positively to the character of the area, the extent to which the building retains its original design features relating to form, materials and detailing. And so, like, for instance, that point, we go back to the Miskel assessment. These are factors that informed the characterization of these buildings, and so that similar language is then flowing through into this policy.
Now, in light of the primary or the contributory, is there in terms of inclusion and the new boundaries that you have drawn up? Is there a hierarchy? Was there how were they drawn up? Was there, oh yeah, okay, that's only a contributory, and there is another one next to it that doesn't look all right, so we just leave that out? Or was it in the streets where you have where you have a consistent character? You have just taken all of them. But it just, when I'm looking at the maps, there are certain areas where I think, why has that been put in and this hasn't? So I just try to understand the process that you have gone through to make your decision on what's in and what's out.
Yes. So that language of primary, contributory, neutral and detractive, that hasn't carried through into the district plan, just to address that point up front. What we looked for in the mapping was concentrations of consistent character. Now, invariably, that concentration of consistent character was primarily composed of primary and contributory buildings. After that, Commissioner, it gets a little bit subjective. There was no real percentage. There's slightly more. We needed, for instance, I don't know, in a given area, 60% primary. We didn't set a threshold like that, but we looked first and foremost for primary, contributory to build on that. If areas were overwhelmingly detractive, that was an easy these around. But
does that mean
there's no science to it?
Does that mean if there is areas that were predominantly contributory and not that many primaries,
they may well have fallen away.
That has fallen away.
They could have fallen away. Yep.
Okay. Yeah.
Yeah.
Okay. Thanks.
Just in terms of the language, you just highlighted that the language hasn't flown through to the district plan. Was it deliberate?
Yes, it was. A few years ago now, I apologise. There was certainly some discussion around whether we could draw a really direct line between some of the rules and policies right back to that assessment. In the end, we decided we couldn't, because it's really just trying to be a bit too black and white. And you'll appreciate, even from submissions, there's dispute about the methodology of that report. So it was really difficult to say this is, if you like, an encyclopedic reference document for us. It is a study. It is, formed by the people that prepared it, etc., and the review that it went through and all of that. And it is a very useful document. We didn't want to be that direct and transparent about it.
The other thing is that it's also not, it's 15 years old and things change.
It's dynamic, absolutely, sir. And then how do you reference that document? I mean, it's a non-statutory document and things involved as well, as you say. So it was complicated. So we tried to take the thrust of it, the fundamental intent, and turn that into more district plan language.
Is your expectation, as you say, you get a demolition application? In practice, that assessment will be the starting point of anyone running an argument, and they might be able to produce evidence to say whatever was the situation when the assessment was done, it's degraded since, so it's no longer whatever. It is making less contribution than it was then. That you could run that kind of argument, but that will be the starting point of the discussion.
I'm sure that document will inform many a resource consent process. Absolutely, yeah. In the same way as any heritage assessment would inform, a resource consent for a heritage building. Time moves on, building condition changes, etc. But you would still go and reference to an underlying study.
Mr. Lewandowski, just on there, I noticed that in precinct 01 policy 2, at least the word contribution of the building to the character is reflected in the policy. So the focus will be on contribution, even though it doesn't use the words primary, secondary, neutral, etc. The focus will be on what any particular building contributes to the character in an assessment because of the word contribution.
Yes, and that I think is trying to reflect that scale of contributions. So it doesn't pull in those 4 words. No. It doesn't pull in that rating scale, but
if you're saying it doesn't need to.
Exactly. It's trying to pull in the acknowledgement that there are better and worse.
Yeah, mere mention of the word contribution will allow a reporting officer to talk about what their contribution is.
Yeah, that's correct. Yeah.
And what's the rule that gives effect to that policy?
That is, I'd better double check. That's R3 from memory, sir.
No. The way these are organised, it's.
Sorry, I apologise. R4.
Yeah, okay. And does that refer back to the policy?
A matter of discretion refers to that policy, correct?
Yes, okay.
The sole matter of discretion.
Yeah. Okay.
I just have to come back, sorry, to what Commissioner Birch was actually referring to in terms of your assessment. So you used the Boffa-Miskell assessment as the basis to work from. You have then refined that in a way by looking how that fits with the NPSUD and the NDRS, and have actually then made a new decision what can and what can't be included. Have you actually had at any point in time thought about having to introduce a new methodology, a completely new methodology? Or have you been relying on that methodology that was basically in the Boffa-Miskel report?
Do you mean a new methodology for the characterization?
Characterization, yeah.
We relied entirely on that
on
one
the-
from the
Yeah.
correct.
So you didn't find that the PUSD would have required you to actually rewrite and come up with a completely new methodology to work that in.
No, because I think that's the second step. The task for that assessment was go and have a look at these character areas as they currently are in the operative plan and consider their character contributions so that we can evaluate our response to these other factors into the PDP. And so that's what was done. An individual site by site, each one, a rating for each one, and then what they also did at the back end was, all right, see, here's some indicative areas. Let's try and find some of these concentrations, not to recommend for inclusion in the plan, but just simply as an exercise. Let's try and find some. And then we took those as the starting point for what was included in the plan. But the actual methodology for identifying, no, revisited that.
Thank you.
Over to you. I think the stream of questions has dried up. I think at this point, I think we've had our overarching discussion on all fronts. Should discuss how we're going to proceed. Do you want to call the expert witnesses now and then to have the expert evidence on the table and then move to the planning? Do you want to? Should we go straight into the detail of Mr. Lewandowski's report if he's got time constraints tomorrow? How do you want to do it? Or do you want to start at objective one for the HRZ?
Just to clarify, sir, my time constraint tomorrow is just 15 minutes. I have to be gone at 4:45 for childcare purposes, so it's not.
I think we can cope with that. Yes, thank you for that. Well, I say the world's yours, as I said to Mr. Wellington. As long as we're, like I would hope we will be finished. We will all be finished by 4:45 tomorrow. And so the question is, how do you want to arrange things from now?
So in terms of the expert evidence from Dr. Zamani and Ms. School, they weren't planning to speak to that. They were taking that as read.
Yes, they certainly will, but
Yep.
we will have some questions for them.
Yeah. So if you have specific questions on them, we can get to that. But possibly maybe if we start with the like you say, from objective one of MRZ to HRZ.
Well, we'll see if there are any questions on your overarching report
Okay.
first, and then we'll go. And then we'll just wade through it.
Sure.
So there are multiple sections, commissioners. Usual rules. We'll do it section by section. And I'll tell you when my next question is, and anyone who's in front of me can go first. I've nothing up to page 17. Any advance on page 17? Well, page 17 is a populous page. Paragraph 38, Mr. Patterson. saying submissions relating to sections the PDP will consider in later hearing streams, specifically walkable catchments. That was news to me. I thought we'd done that.
Yeah, that appears to be an error. Yeah, I anticipated that was addressed in stream 1.
Good.
Page 7.
17.
There are multiple page 17s.
Oh,
That's a page 17.
that's a tricky one. Hey, yes. All right. So that was yes.
I was a bit confused as well. I was thinking paragraph 38, page 17. But
130, so.
Okay, so that was paragraph 38. Any advance on paragraph 38?
The other 17.
sorry about that.
Okay, so
Yeah. Yeah.
my next question was paragraph 104. Paragraph 104. Any advance on paragraph 104?
Yeah.
This is 3 waters. So you're saying, what does adequately serviced mean? And I'll tell you why, because
Okay.
there are 2 concepts here. There's a pipe going past the front gate.
Yeah.
The pipe can accept whatever's coming off a property. But there's a network restriction, 100 metres, a kilometre down the pipe, the whole network is constrained, which works its way back up the pipe, of course. So what does that adequately serviced mean in the context of the wastewater network in particular, since that's the one that has the most obvious and quickest adverse effects if its capacity is exceeded? And if it's not clear, does it need to be made clear?
Sure. I'm just reading the paragraph 104.
And you have recommended it's able to be adequately serviced, which
Yes.
conveys the concept of, well, it might not be right this minute, but there's a plan.
That's what the intention was, and that's what I was just looking at, making sure that that's the case. So the recommendation,
which is a different consideration.
it is, yeah. So I think the recommendation made there is to recognise that it may not be able to be adequately serviced, but that it is able to be in the future, so as not to constrain development at that point in time.
So just pick, all right, we'll stay with the first question because I've got a follow up about able to be, but stay with the first question. What does adequately serviced mean?
So it's not defined in the PDP itself. Adequately serviced. That's something that I'll probably have to have a think about and come back to you on.
Wellington Water have like terms of service that you can reference that govern those wider network issues.
Yeah, and also I just point out that it's also in relation to the Three Waters chapter. So going back to the district-wide matters that apply, making sure you comply with what's in the Three Waters chapter would suffice, or it would give effect to that policy.
But the trouble is that's not what the policy says. Policy is standalone. It doesn't refer you to the Three Waters. It says, well, you're recommending, say, is able to be adequately serviced by Three Waters infrastructure. If it said as provided for in policy XYZ of Three Waters chapter, that'd be a different matter. But it doesn't. It's a standalone. You wouldn't, if you were applying for a consent, you'd go no further.
Yeah, understand. I think I would argue that the intent is that you do look back to the Three Waters chapter as a matter of course, regardless, and that the adequately does intend to be referring to that Three Waters chapter. If you were of a mind that it needed to be clearer in that respect, I would certainly think that that's something that can be considered.
Well, let's leave you to ponder that one.
Yeah.
And in terms of the able to be,
Can I try and assist on that?
Yeah.
So P6, policy 6, MRZ P6, which is what paragraph 104 refers to, says that the plan provides for multi-unit housing where it can be demonstrated that the development in sub 4 is adequately serviced by Three Waters infrastructure. And Three Waters infrastructure is defined. It means network infrastructure for water supply, wastewater or stormwater to the extent it's controlled by the Council or Wellington Water. One way of interpreting that is that it's a network approach. So if there is a downstream blockage or an inadequacy in the entire network to be able to address that issue, then it's
on which we know there are many.
yeah, then that would not be adequately serviced. But at the same time, I can see a counter argument that adequately serviced sort of relates not so much to a future plan, because it's serviced as a past tense. It's an existing state of affairs. So if it's about the state of the particular pipe at the time, then it may well be that the pipe that it goes to that particular development site is capable of taking the amount of water that will come out of that property. And so it may well be that to address the concern that you might have about what that means, not so much about what it should provide for, but does it accurately state what the intent is? There may be some tweak required to the way that that's framed to make sure that it's a network approach, if that's what's considered appropriate.
And in terms of the able to be, that's about theoretical possibility. Should it not refer somewhere somehow to there being an actual plan or a funded plan even? Because I'm aware that local authorities have any number of plans, but the rubber hits the road when someone has to find the money. So is able to be serviced, adequately serviced, could mean there is a possibility that it can be. Able has a wide connotation of so does it need to be more in terms of that, to the extent that it can't currently be, it will be serviced because there's a funded plan that to upgrade the network, which when complete, which coincides with the time frame of the development, that all of those sort of considerations to make that clearer.
Yeah, I also consider that when you go through that resource consent process, and Wellington Water has an input, you will have to respond to that, and providing evidence and how that will be adequately serviced will be a requirement.
But again, like if the language is loose, then what you have to do what you have to demonstrate is correspondingly loose, and that if this is, well, this comes back to I raised earlier, just how sharp are those provisions? So if no matter how good or how bad the Three Waters provisions, if this policy has a hole big enough to drive a truck through, somebody will. In fact, several people will. So so I think I should leave that thought with you.
Okay.
Just to dip my oar into this one, Commissioner Robinson.
All contributions are welcome.
Three Waters Policy 4 talks about Three Waters infrastructure servicing subdivision and development is serviced by Three Waters that meets the standard, the Wellington water standard, has sufficient capacity, and then thirdly is in position prior to the commencement of construction, which I think
That's the kind of language I had in mind, and it's the fact that language is not in this policy.
that's what I was just driving at. I think your issue, if I'm hearing the question correctly, is does it need to sit in the residential? Does it need to sit in the Three Waters, or is there an appropriate
Cross-reference between the two?
I think that's the question.
That's my point. Like, I'm not necessarily suggesting that the language of this chapter needs to pick up all of the nuances in the Three Waters chapter, but it needs to be clear to me that this is not a one-stop shop. Because that is, say somebody will argue that this is sufficiently standalone that they can ignore what the Three Waters chapter says.
I don't think there's a dispute that the district-wide matters apply in addition to zone-based chapters. But I think your point is that sufficiently clear?
Yes, indeed, and in particular for yeah, it's the cute lawyer's argument. Can we avoid the whole issue by tweaking the words?
Yeah, I think that's something that I will look at and consider.
It's like it could be tweaking the words, could be a cross-reference
Yeah.
to the Three Waters chapter. There are heaps of different options.
Maybe just looking at the introduction, so maybe a sentence in the introduction to that
Sure. Yeah.
chapter, so that there's a cross-reference, if you like, to Three Waters, just highlighting the importance of that.
Sure. Noted.
I'm up to paragraph 135, questions? Answer 135?
Yeah.
Right.
130, just as a clarification.
130 or 13?
130, 30. And I think that just flows in quite nicely with the Three Waters chapter. You say in here that you're not referring to that because it's in the transport chapter. The transport chapter is an overarching chapter, so there's the same thing that everybody needs to go through that, no matter what. So that is a trigger that any new building will have to adhere to that.
Yes.
Yes.
Yeah, it is.
Okay. Thanks.
Sorry to backtrack to one paragraph. Yeah, I was just had a question on one.
You're not fast enough, Commissioner.
Definitely not.
Yeah.
So I just had a question, and I know this has come through in submissions too about residential design guides. Is, you know, how do you meet the intent of the guide? I'm struggling with that myself. I think we might come on to it later when we get a bit more of a discussion about how it works. But I just want to, flag this one now because it's come through on submissions a lot, and it's just there seems to be a lot of, just a lot of grey area about how we meet this and the intent of the design guide. And just in terms of multi-unit housing, I know you've made a slight change there now, but just to say that you've clarified about, like retirement villages, for example, multi-unit housing. there that they, you've slightly softened your language there. Just wonder if you could just elaborate on that a bit more.
Sure, I'll just go back to it.
So yeah, that's policy 6. You've got where it is relevant. Fulfills the intent of the residential design guide. I just wonder if that's just a whole of problems with both those sort of statements.
Are we talking about changes to what zone?
So this is HRZ.
HRZ.
Yeah, and I'm just looking really at probably it's policy 6 that we're talking about here.
I think they're the same either way. I think the
It's
policy,
the same, and it's the same as medium as well. Yeah, it's exactly the same.
So I'm looking at HRZ P6 and Appendix A, and I can't see the change that you're referring to.
I think it's in P7, the where it's relevant.
But it's actually both. It's multi-unit and it's retirement villages. So it's P6 and 7.
Oh, yes, I see. So could you just remind me of what the original question was?
So, well, 2 questions is how do you fulfill the intent of a residential guide? And it came through in submissions as how that's difficult to interpret. And in particular, retirement villages and multi-unit housing submitters also thought, well, you know, those guides aren't necessarily totally applicable to a residential dwelling, if you like. And so I'm surmising that you've introduced a little bit of softening there as you put the words, you know, where it is relevant. But I just still want to understand is how do you fulfill the intent of the guide where it is relevant?
Put it another way, what's the intent of the guides?
Sure. I think I would like to address how do you fulfill the intent of the residential design guides once Dr. Zamani is being asked. He's referenced it in his statement of evidence, so I think I'd like to wait until that. In terms of that, where it is relevant, the intended change was, as you say, to soften the wording a little bit to make sure that applicants or plan users are aware that not every part of the guideline will apply. It will only be those that are relevant. And in terms of, I think the second part of the question was, how do you determine what's relevant? Is that right? Yeah. That will come out in a resource consent application in consultation with the planner as well. But also some of them will be clearly relevant, some won't, and you can make an argument as to why you think that is the case and why it is not.
The follow-up to that would suggest that the design guides need to be clear on their face about what is relevant to what, surely. So I was going to ask you a question because this is part of the retirement villages case we heard in stream 1. They don't think the council has any business directing them on how they attend to the internal amenity, how has any directing the internal amenity within an environment within a retirement village. Are the other design guides relevant at all to the internal operation of a retirement village? Wasn't clear to me.
Yeah, Mr. Patterson, just further that the meaning of words is going to become important later on, and the reference to intent is particularly important. I've seen it expressed in other jurisdictions as consistent with, compatible with.
And then the issue is, which elements of the design guide does it have to be consistent with? Some of them or all of them? And if it's some of them, which ones?
And in light of the opposition by some of the submitters, I'm thinking of the evidence of Mr. McIndoe, where he feels that the design guides are overwhelmingly lacking clarity, duplicative. It's important that when you use the words intent, you know exactly what part of the design, whether it's the design guide as a whole, is it the objectives of the design guide, or is it each individual design guide and a checklist approach? I'm assuming it's not the latter, but without some guidance in the policy itself, it's left to each individual resource consent to sort that out.
And well, just to layer that, another criticism in the submissions and the evidence for submitters is that if it's not clear what's relevant, then that's just adding cost to the building process while they debate what they need to worry about and what they don't with the council officers.
Okay, so there was a lot there.
Yeah, there is. And it's 5 minutes to the lunch.
Yeah.
And so I'm not suggesting you answer all of those questions we've thrown. So I think that probably there's a row of the message you should get is there's a vestige of concern on this side of the table as to how clear, and Mr. Burge is sort of taken paragraph 129 as a little lightning rod for that concern, but it's across a much wider area about, well, how are these design guides written? What is the intent of the design guide? Is that clear? What is relevant? How do you determine what's relevant? Who determines what's relevant?
It also presents itself in the matters of discretion, the wording used to reference the particular design guide under that matter of discretion.
But I appreciate that between the three of us, we probably asked you about 14 questions. So on that note, we'll probably adjourn for lunch, and you can give us your initial response, and not necessarily on a point by point. The answer to the first question is this, and the answer to the 14th question is that. But a general response, because I think that we'll end up talking in greater detail with Dr. Samani about it.
Yes. Yeah, you will. Okay, we'll do that.
Thank you. We'll adjourn. And can you cope with 3/4 of an hour? We start at 1:15.
Yeah, that's fine.
All right. Adjourn till 1:15.
Thank you. Oh, no.
Just briefly, Jamie.
Yeah.
Josh, conclusions based on models. So it might be doesn't have yes. And one of the requesting that it did they can't ask for it. It is what it is, but
Little way around that, yeah. Seem to be missing one question.
Ordinarily the front.
Zoom the hearing. Now, Mr. Patterson, the questions were coming thick and fast. I don't even know if you took a note of them all. But I think there are more precursors of a range of issues that we want to talk through with you and Dr. Zabani. And maybe it's in the opposite order of Dr. Zabani and then you. But do you want to give us a preliminary response now, or do you want to say, yes, we're taking on those on board and we'll address them as they come, or how do you want to play it?
Maybe if I give a preliminary response and then hand over to Dr. Zamani to answer any specific questions.
Yes, but might be more than a few specific questions. I think if we're going to do that, maybe we get your preliminary response. We'll finish the overarching report and then hear Dr. Zamani on his evidence in toto, and we'll wrap the design guides into that. Is that okay with you?
That's okay with me.
That's Dr. Zamani. All good. Yeah, so the preliminary response.
So just to note that the residential design guide and the guidelines within them are intended to start a conversation with applicants. It's not the case that every guideline has to be met for the intent of the residential design guide to be fulfilled. And I'd also like to point out that there is the introduction to the design guides, and that document should be read by everyone who's using the plan. That spells out key principles and key outcomes. When you meet those principles and outcomes, you fulfill the intent of the residential design guide. That doesn't mean, as I said, you have to meet every guideline. It could mean that you meet 10 guidelines, but you fulfill those key principles and outcomes.
The obvious question, to me is, does the introduction actually say that in words of one syllable? But just hold that thought rather than.
Okay.
So that's my immediate reaction. Yes, understand that.
Yeah. So the introduction, I'll just touch on that.
Yeah.
Does say does spell out that the guidelines should start a conversation, and that they're most effective when you do engage initially. So to that extent, they do.
With respect, that's a different matter altogether, Mr. Patterson. That's encouraging a dialogue. It's whether what you just said about meeting the intent of the guideline, whether that's captured in the introduction is what we're really interested in. One thing to have a conversation and have that early, and that's to be absolutely to be encouraged.
Okay.
It's whether the introduction makes it clear that, in other words, I've written down are that the key principles and outcomes, the intents are met.
If it's okay, I know we said we'll hear from Dr. Zamani soon, but perhaps if Dr. Zamani comes in now and
so we're just giving you feedback.
Yeah.
And so although it's in the form of a question, I think we're just putting the questions on the table.
Okay.
Rather than inviting a specific immediate response. So, I've started and the commission's carried on and interrupting you. So we should stop doing that, and we should let you finish your preliminary comments.
Okay.
So,
there was another point there that was raised about the number of guidelines that you have to that are within the residential design guide, and whether some of those could be brought up a level or conflated. As mentioned earlier today, we have done that to the guidelines where we see that as appropriate, but we note that rationalisation is not always possible, and the reason for that is you may miss, by doing that, you may miss some important elements of the guidelines which you're trying to conflate. And so we've done that assessment and we've determined that the ones we haven't rationalised or conflated need to stay as they are for that reason. And that is an initial response.
Okay, that's all good. Yeah. And I think we'll just save our powder for Dr. Zamani team. Going on to paragraph 135, change of pace. Your last sentence, I consider this out of scope. I've written in my margin. Why? Question mark.
I don't consider that it's the responsibility of the district plan to be determining what's affordable and what's not affordable. I also consider that defining affordable is quite difficult, and to my understanding, there isn't a clear or good working definition of what affordable is.
Okay. My next question is paragraph 162. Any advance on 162? All right. What number?
142.
142 is first.
Thank you. Mr. Patterson, the section starting at 142 on general points on sunlight and shading and going right through to page 17, the other page 17. Starts off
165.
165.
yes. Starts off summarising the number of submissions that have been received in relation to effects on shading from increased intensity and effects on solar panel matters. I just wondered, in the section 32, had there been any consideration to adopting sunlight as a qualifying matter in terms of section 77? In the same way that character had been adopted as one of those discretionary matters.
No, I don't believe that it was ever a consideration to adopt sunlight as a qualifying matter.
Yeah. Is that, and that's sufficient as an answer, but is there any documentation that it was considered and not followed through?
That's something that I can't tell you off the top of my head. I'd need to go back to the documents and
I couldn't find anything that directive in the 32, but it's a large document and I may have missed it.
Yeah.
Could you follow that through?
Yeah, I can do that.
Yeah. And the answer, well, I'll be interested in the answer, but I suspect there's quite a bit of reference to other techniques to achieve that through, such as the height in relation to boundary approach. So that's, I guess that comes down to a method of achieving sunlight emission, or another method could have been adopting it as a qualifying matter. So what I'm particularly wondering is whether section 32 assessed different options for achieving sunlight emission other than just the height in relation to boundary option. And it may well be that the answer is no, it didn't. But where that was put to one side in the section 32, I'd be interested in knowing.
Okay, yeah, I will look at that.
That makes sense.
Yeah, it does make sense.
Thanks.
161 was the bit. Am I left or right?
My question there is in regards to solar panel shading.
Oh, yes.
And I just sort of turned my mind back to your strategic objectives. And question gone, hang on. The CRCC01. And I just wondered whether, in response to that, whether you had actually turned your mind to that strategic objective.
What was that number, please, Commissioner?
SRCC01.
CC01.
Which talks about, you know, increased use of renewable energy sources, more energy efficient buildings, and the built environment supports achieving a net zero emissions by 2050. So I just wondered how you can, you know, whether you sort of turned your mind to that objective when when you're assessing these issues.
If you just give me a second, I'll just reread paragraph 161.
Sure.
Yeah.
Yeah.
And what was the objective number? Was it S?
SRCC01.
One. Oh yeah, I see. See what you're asking.
You sort of dismissed it as being an unavoidable impact.
Mm.
And I just, you know, I don't know that quite cuts the mustard for a lot of matters. So
I think it comes back to the need to balance needing to increase intensification and increase dwelling numbers to meet population growth alongside other needs as well, such as providing for solar panels. And in consideration, I think that where we landed does take that into account. I mean, you still have the height in relation to boundary controls that apply. You've still got the setback controls that apply. So using those methods, I think you will achieve on majority of sites, I believe that you will be able to utilise solar panels effectively. At the same time, we're enabling more intensive development, if that helps answer the question.
So your methods are your height in relation to boundary and
Yeah.
your setbacks, and you consider it's a sort of follow on from Commissioner McMahon's question about shading.
Mm.
So you think that they are adequate to meet the needs of a solar panel, if you like, that's existing?
Yes,
New build was happening.
yes, I do.
Can I follow up and suggest that there's an inconsistency between the reasoning of 161 and 162? 161, you say you're an unavoidable impact. 162, controls are adequate. So those two statements don't quite gel. And the follow-up question is, have you or the council assessed the level of sunlight loss under those standards? You've given us your feeling that the majority of solar panels won't be affected, but has there been any attempt to quantify what the effect of the standards is on adjacent sites? And is it influenced by topography? I've just come out of a hearing in Pairua where the council distinguished between general loss of sunlight and sunlight that people at the bottom of slopes, south-facing slopes, encounter. And Pairua has identified a qualifying matter for the latter. So, as I say, two questions there. There is an apparent quantification. Is it unavoidable? And to the extent that it's unavoidable, how much loss of sunlight is there going to be?
Yeah, understand. I think if we go back to the need to provide for more housing and more intensification, some loss of sunlight is an inevitable outcome of doing that. And I think that goes back to the NPSUD as well, and acknowledging that the immunity of the current environment will change. It's not going to stay the same, it will evolve. And that's one of the outcomes of enabling high intensification than what we do have under the current ODP. And as I said, I am of the view that we have achieved a balance of providing that intensification whilst providing protection to the to as much of the existing amenity of Wellington City as possible. So that's that balancing act.
Well, I suppose the key point is that how do you know that you've achieved a proper balance if you haven't quantified the adverse effect?
I do believe there was some modelling done on sunlight or hard relation boundary recession planes. I haven't got that knowledge to the top of my head, so that is something I'll have to go away and have a look at.
So I think you had a question around this area too.
Yes, I had exactly the same question actually as Commissioner Birch, but there was another thing that just came up in addition to that. We were saying we will be able to use solar panel. People will be able to use solar panels still, so there is not a it's not completely taking solar panels out of the equation. And this is how you have, with the height in relation to boundary and setbacks, is how you balance the intensification with the carbon emissions and all of that. Are you taking, because there will be buildings, because buildings that go up are new, there will be buildings that are sitting there, and I think the submissions that we have is not from people necessarily who might consider in the future to put solar panels up, but who have solar panels at the moment and are fearing that the tens of thousands of dollars that they have actually spent to get them up, where they get sun now, they will not have the sun later. And I'm not quite sure, are you actually taking that into considerations in any applications for new buildings that come in? Or is that then referring back to what you said here, that's just an unavoidable impact?
Yeah, I think, I mean, there will be opportunities in a resource consent sometimes, because I acknowledge that not all the time you have the opportunity, but for neighbours to have a say on what the development happening next door, what the implications of that are through notification. But I acknowledge that's not going to happen every time, but there will be times when it does. And I do go back to my point that we have responded to the legislation and the need for more housing by providing intensification, whilst trying to balance that with protecting sunlight through, like you mentioned, high relation boundary and setbacks. And I am of the view that we've reached that balance. That's my response.
Related question. How many people in Wellington City do have solar panels on their roofs? I suppose I look around me and I've now moved to Havelock and they're everywhere. Yeah. You get a bit more sun in Havelock than you do here. And I'm just trying to think, looking around, I'm not conscious of a whole lot of solar panels on roofs. But maybe that's just an impression I have.
Yeah, have to.
You don't tend to go around looking at people's roofs.
Yeah, like I say, I have to admit, I haven't seen many, but.
So should we do a straw poll of the council team of 4 in front of us? How many have solar panels on their roofs?
I am looking at some right now, Commissioner, that was what I was pointing at.
And
Random sample of all those in the audience. Put up your hand if you have solar panels. The fact that it's pouring with rain outside is just incidental.
I was going to say that I'm looking at them as well, but so oh, well,
Yeah,
I
but
think
going
that's-
back to, like, is the mass penetration at the moment, like the commissioner's question about, you know, existing people with solar panels, do you have any sense of the number of houses that would have solar panels in Wellington City?
No, I don't.
we can go away and see whether there's any easy way of the council finding that out, whether that's by,
Whether ECA would know, for
Yes.
instance.
that's right. Going back, I've just been poring over 161 and 162 because I don't see the same inconsistency of approach that you might be reading in. It's just gone off. The reason being that they come at things from a slightly different, almost temporal perspective. 161 is saying that where solar panels are on existing dwellings, then the increased shading, for want of a better word, that is going to be an impact from the greater level of residential development is an unavoidable impact. It's been directed. Now the council could have thought about a qualifying matter where, you know, that applied to any dwellings that have existing solar panels, and that would have, you know, raised, no doubt, there would have been a huge influx of people trying to get solar panels on their houses before these rules take effect. But that's
very cynical.
That's really by the by. But there's that issue. That's about existing. The 162 is about a future-looking question of what the standards related to development that are encapsulated in the NDRS and the high density in relation to policy 3. Now, when Mr. Patterson says they're considered sufficient to address sunlight concerns, that's almost a trite statement because it's future-looking. The legislation and the NPS require or have designed the standards to enable a level of sunlight concentration that the drafters consider to be appropriate, or consider to be appropriate in light of the impetus to have urban development and the intensification that it's directing. So because they come from things at different angles, I don't see quite the same obvious inconsistency.
Having suggested that a little cynical, I wonder if you're being a little naive, suggesting that the forces of central government gave any great consideration to the adverse effects of intensification standards, because in stream 1 we were told that the cost benefit analysis said there would be no adverse social effects from intensification, and I've seen urban design commentary saying there will assuredly be both loss of sunlight and adverse social effect. Now, the answer to that is, well, the NPS is what it is, and whatever the robustness or otherwise of its technical underpinnings, it's a higher order document that we're bound to give effect to.
Well, that's exactly right. But I was careful not to say that this was all gone through in the regulatory impact statement and all of the underlying work that went into the NPS and the legislation. I don't know the extent to which it went into those sorts of questions. Maybe not enough, but the answer is that it is what it is. That's the direction that we are implementing, and Parliament has made a judgment call, for better or worse, based on the information that was in front of the drafters when they drafted it and when they put it before Parliament for consideration.
Yeah, I think there's two different things to the sunlight. There's one is the amenity value, and we don't even go there right now what amenity means, but the amenity value of people wanting to have sunlight because it's just nice to sit in the sun. But there is the other issue, and I can see that, you know, we have been told by the NPSUD that we need to intensify. The other hand says, yes, we need to intensify, but we also need to actually be aware of our carbon emissions, and we need to be at carbon zero. And this is where sunlight comes in again. And I think that has a completely different level of impact and hierarchy than just the amenity value.
The other thing is that, of course, the NPS REG says that renewable electricity generation is nationally significant, irrespective of quantum. So distributed generation is.
Yeah. And I don't disagree with any of that. It may well be that what was envisaged is that all of the dwellings will go up, and therefore there's an equal opportunity for each site to have solar access, because if your neighbours go up, that's what you should do too. What hasn't considered is the situation, to go back to 161, on people who have invested thousands of dollars on solar panels already, and whether it affects them to any great degree. And the position is that the council's not proposing a qualifying matter to preclude intensification on sites surrounding houses that have solar panels already implemented.
Yes, and I understand that, Mr. Wellington. Just going back a step, all I was asking of Mr. Patterson was to direct the panel to any Section 32 assessment that explains why the effects on shading haven't been used as a qualifying matter, and explain why the effects of shading, that's in an amenity sense, and the effects on shading on solar panels hasn't been a consideration. And it may be that there is nothing, but it'd be valid to know that.
Oh, absolutely, and we can go through that. While you were talking about it, I was searching the Section 32 for the word sunlight, and it doesn't appear to occur.
Yeah, and you
that's
know,
on my phone.
You can understand why we're asking these questions, having just come out of the oral hearing where it's converse.
That's right.
Shading front and foremost as a qualifying matter, in the same way that character areas are here. And you know, this idea, I don't want to be critical, Mr. Patterson, but to say that there's no effect without knowing what the quantitative answer is something that needs to be. You need to be careful when you make those sort of comments.
Yeah, sure. I don't think I said that there's no effect. I acknowledge that there likely is to be some effect, but I think we've balanced that the need to provide housing alongside protecting.
Sure.
Yeah.
And to be fair, you did use the word. You said the balance being achieved between providing intensification and protecting sunlight through height in relation to boundaries. So, that's right. But it's just about where that balance lies without a quantitative assessment that the panel's in a bit of a quandary about.
Okay.
Question. Paragraph 253. Advance on 253. Same question, the previous one. You said not considered appropriate to incorporate this proposal PDP. Answer. Question. Why not?
I think that comes back to the fact that through the PDP we've given effect to the NPSUD and the MDRS. We did not consider that the plan presented by the new town, by Catherine Underwood, had done that. So more appropriate to keep with the PDP.
Shoot the messenger. Mr. Patterson, I react to the when any planning witness says we.
Yeah, I've been trying to avoid it. Yeah.
While our late Queen could talk about we, I don't think you're in that position.
No, I acknowledge that. I apologise. I'll make sure I pay attention to that.
Thank you. Anything else on the overarching report team? Okay, we're up to Zabani. I think Dr. Zabani, we should invite you to summarise or pull any important points out of your evidence. More generally, we've given any number of suggestions of as to the areas of the design guides that are troubling us, and if you want to focus on them and in effect anticipate where they're coming from and answer it, that's fine, or wait for questions, that's fine too. It's over to you.
Kia ora. My name is Farzad Zamani, and as my statement of witness explains, I'm an urban designer with background in architecture and urban design, both and also private and public sectors. I will not go through my evidence, and I consider that's read. But the first matter that I would like to discuss is the question around the intent and use of the design guides. If you don't mind, I will read a couple of sentences from the design guides introduction chapter, but also the introduction of residential design guides that I hope would clarify some of your questions. So firstly is the introduction chapter of the design guides, page 5, under the heading of design outcomes. The design guides states that design outcomes are intended to support the design principles and achievement of good design across Wellington. While the design guides are ultimately outcome focused, the specific guidance should not be used as a strict template or planning rules, nor should it be reduced. Nor should it reduce the potential diversity of design approaches taken. This was one of the critical aspects for us when we reviewed the design guides, to ensure that the design guides are used as an outcome and principle based document rather than as a checklist to be complied with, similar to the standards. And I believe that this is clearly stated in the design guides. It also states that the council anticipate guidance to be interpreted and used appropriately by resource concerned applicants and advisor, so as to achieve good design that meets the overarching outcomes and principles of the design guides. Again, this was trying to emphasize that the specific design guides may not be relevant to each application or each development. In the residential design guides, the introduction of residential design guides under the heading of application, the first heading, it states that the following guidance is designed to apply to a wide range of housing typologies, from multi-unit housing or mixed-use development to single-family homes. The district plan rules will set their specific requirements, such as building height or building setback requirements, consistent with the overarching objectives and policies of the relevant chapter. This guidance that follows here is not meant to replicate or replace such rules, but rather to ensure best practice design approaches and encourage built outcomes that both support the district plan objectives and meet the design guide's overarching principles and outcomes. So it's kind of 3 times it's been repeated that the outcomes and principles are the most important aspect of the design guides. And this was something that I tried to clarify further in my statement of the witness statement. And I'm happy to take more questions regarding the intent of the design guides and how it's supposed to be used.
The first question might be, we've talked about the policy that refers to the intent of the design guides. Should rather than it be the intent of the design guidelines, should it refer to the design principles and design outcomes stated in the design guidelines, so that the guidelines are then in aid, and only in aid, to as to how those guidelines might, and those outcomes and principles might be, the outcomes might be achieved and the principles might be applied.
I cannot comment on behalf of Mr. Patterson.
What's that, sorry?
I cannot comment on behalf of my colleague, but I think that's the intention of.
When we've got technical underpinning,
Yeah.
we'll ask Mr. Patterson about
Yeah.
how it's given effect. But from your point of view,
That's correct.
it's the focus is on the design principles and the design outcomes.
That's correct.
And I think that the thing that I reacted to, like I understand the introduction says all of those things. The thing I reacted to is the language of the guidelines. Like Commissioner Burge asked, well, how does this 3 dot system work? Because if the three dots say essential, then irrespective of what the introduction is concerned, anyone reading this document is going to think, well, that means what it says. This is essential. There is no opportunity to second guess that. Like in terms of Mr. Patterson's report talks about these operating as priorities. Saying something's essential is a bit more than saying it's a priority. And that might be the source of a lot of the confusion. It certainly confused me about the mixed messages, as you say, between the introduction. The introduction is perfectly clear, and you've assisted by that by pulling it out of a separate document. Mr. Counsel recommended pulling it out of a separate document into each introduction. But is the language of the design guide, say, essential, summarize, paraphrasing, 1's essential, or 3 dots is essential, 2 dots is you better have a really good reason not to do it, and 1 dot is nice to have. Is there room to clarify it consistent with the introduction to say that 3 dots are, these are the things that are likely to be needed to achieve the design outcomes. 2 dots means a step down, not likely to be needed, but more likely than not, or something like that. And 1 dot is maybe relevant, need to be considered, that kind of thing, to reframe the whole 3 dots thing.
So the short answer is yes. I think there is always room for further clarification, specifically if that helps the applicants with that level of confusion that you just mentioned. The longer answer would be and I will explain how the DOTS system works first. So the DOTS system was a result of number of submissions that we received on the draft district plan, and that was a concern that what kind of design guides are required to achieve those outcomes. So the 3 dots are essential to achieve the outcomes, not necessarily to achieve a good urban design. So, or like support of an urban designer for a resource consent application. So it's around the language that we use here. So it's essential to achieve those principles and outcome. However, the design guide introduction chapter states that you may do something different and you have diversity of approaches to achieve those outcomes and principles. The 2 dot kind of design guides are the ones that they're not essential, but they may actually improve the outcomes of the design and a development or a building. And the 1 dot design guidelines are the ones that we anticipate they either practically not possible in most cases, or they are very high standard for a lot of building, or there's different constructability difficulties around those specific design outcomes. So we put them on a 1 dot kind of rating. But going back to my initial short answer, we can clarify that in our right of reply to make sure that this is crystal clear, that even the 3 design outcomes are not needed to be complied with to achieve those outcomes and principles.
Well, if they're not needed, then essential is clearly the wrong word. That, like, essential to me is there is no alternative. You must do this, and like that shrieks of a standard. Saying something is essential, like even if the reference point is the design outcomes and the design principles, to then say something, never mind the fact that I think Mr. Hitchie said there were 67 3-dotted guidelines, is essential, is not telling me that there are other alternatives. It's saying there is no other alternative. So, like, we're not here to wordsmith this, but that's my reaction is saying, you're telling me 2 different things. One, it's essential to achieve the outcomes, and secondly, you might be able to do this some other way. Well, I think that then it's not essential.
My response to that, I think, goes back to the complexity of design and the nuances that different sites have. Parts of the design guides may not actually be applicable at all. Even the headings of the design guides may not be applicable. So essential, again, it goes back to the intent of the design guides. The design guides are not intended to be treated as a checklist. And therefore, when it's needed, it may be essential to do certain things to achieve those certain outcomes, but sometimes it's not needed to consider all different aspects that mentioned in the design guide chapter, residential design guides, or other chapters of the design guides.
Understand, and I posed the question earlier about retirement village. I've been around the houses once already in stream 1. Particular concern of the retirement village companies and their association is the council wanting to stick its oar in as to how the internal parts of a retirement village are designed so that that's solely about internal amenity rather than the external interface. And to your mind, are these design guides relevant to the internal amenity of retirement villages?
So when you raised that question, I thought about it during the lunch break too, and I believe that this will be exactly the similar process that we do use with the operative design guides. So the operative design guides, when they apply, the urban design advisors will consider those nuances, those special circumstances. It applies to retirement village development, student accommodation development. Of course, all of these, we can't apply the same residential design guides that we have for a multi-unit development to a student accommodation or a retirement village. And that's where the urban design advisors would consider that as a different scenario. So part of the design guide would apply, part of it may not be applicable. What is applicable is those good urban design outcomes that they are generic enough to achieve good city design, and that would apply to a retirement village. Of course, many of the specific residential design guides will not apply to a retirement village development.
And like the question I posed, maybe it's a planner's question. Who decides what's relevant and what isn't?
That'll be determined through a resource consent process.
Well, that comes back to what I made earlier, that if an applicant doesn't know what's relevant, what's not, that's going to impose costs on the applicant. No purpose.
Yeah, the purpose is to work through the design guide with the council. It's not to come in and and guide it by yourself, it really is beneficial to engage council along the way, and that way you will avoid those sorts of costs.
Commissioners, I'm conscious that I've hogged that.
Just in your line of what you just said, how do you get across, or where in the design guidelines does it actually no, I need to go from a different angle. Design guidelines are typically not for planners. Design guidelines are for architects. That's my understanding of the matter. How do you get, with the introduction that you have in your design guidelines and with the reference that you have in your plan, how do you get an architect to look at that before they start designing, and how do you get, question number 2, that dialogue going early enough to not have at the end of the day a planner taking the design guideline and says, okay, there is the design that has been done, and here I am trying to fit it in somehow into the outcomes, and somehow we will get it there. And you know, you will come back and say, oh yeah, this and this needs to be moved a bit. Just from a practical point of view, how did you envisage that to work?
Well, I suppose the simple answer is, and in my experience as well, for those sorts of developments, a planner would be consulted with as a consultant prior to anything, any drawings happening. So an architect would talk to a planner and get those sorts of views prior to designing would be the ideal situation, and is what happens a lot of the times as well.
And I can see that very well for larger developments, but I understand this is actually a document that applies to more than 4. And if you just have 4, because that's just the thing to bring it over the line, there is a lot of developments that I, as an architect with architectural background, know that they are done by all sorts of people that are not necessarily architects, but have other qualifications, and where a planner has not been engaged because it's just one side, and it's not that big a deal in some people's view. So the question is, if the design guides need to make sure that we have a certain quality out there, we need to make sure that people are aware of it for a start, that they can read it, that it's easy enough to understand, and that they know what to do with it. And there needs to be a clear guideline. And I think that having the introduction is a good start, but I'm just wondering how would it dealt with to actually get people to read it, to be quite blunt.
There is a paragraph in the design guides stating exactly what you just mentioned, because this is an operational problem for us, that applicants come to fitting their design into whether it's operative design guides or the proposed one. This is an issue that's been around for a long period of time, and we've seen it. So we indicated that before starting any kind of design, the review of the design guide would be helpful. However, my belief is that we don't have a statutory tool to force anyone to read the design guides before they engage with council. Where exactly in the plan is that stated then? It's in the introduction chapter of the design guides.
Yeah, but since the design guide, I'm not quite sure how to explain it. The design guide is actually something that might be looked at or not. It's the plan that will be looked at, and I'm just wondering where in the plan does it say you must have a look there, and this is something that needs to happen as early as possible. Because I think without that, people will have done all the things that you have in the plan, and then at the last moment say, oh, there was a design guide, maybe I should have looked at that.
So the intent of having it in the policy was to signal that the residential design guide is going to be applicable, at which point you will need to have a look at the residential design guide as well as the introduction that's associated with it.
And where in the plan does it?
So that's in your policy, MRZ P6 and HRZ P6. I
Okay.
believe P7 as well under
The
both.
P7, yeah.
Yes.
Yeah. Okay, thank you.
Any more on design guides?
Thank you, Mr. Zamani. I think that's been a really useful conversation. Can I just record for the record your response to earlier that you did see some merit in the policy being rewritten to focus on the overlying principles and outcomes in terms of the
Maybe
intent?
not that the policy being rewritten, that there will be a focus. We'll talk about to Mr. Patterson about where
Yes.
that's captured.
Okay, let me rephrase that then. You agree that that the focus of the plan, whether it's in policies or rules, should be on the intent in relation to the overarching principles and outcomes.
That is correct. So that was the statement I made, was in relation to the quote of Mr. Patterson in terms of the intent of design guide.
Yes.
I do agree that probably would be more clearer if we say the intent of the design guide, the intent of the outcomes or principles of the design guides. So inclusion of the outcomes and principles into that statement.
Thank you.
I don't have a problem with that.
And
Thank
should they be relevant principles and
Yes. That's useful. I think there's no doubt what the intent is. I'm not sorry, I don't mean to use that word. What the purpose of the guidelines are. It's just matching the wording so that all users of the guidelines, not just the council, but applicants and I guess submitters, know with clarity where the focus lies. Okay. I guess that just leaves a question for Mr. Patterson, and you may come back to this, Mr. Patterson, and that's on a typical matter of discretion where the design guideline is listed as a matter of discretion. And I'm just looking at MRZ R5 precinct 01. It's simple in this case, it's item number 2. And it simply refers to the matters, sorry, item number 3, it refers to the residential design guide character precincts appendix. What I'm unsure of is what that matter of discretion is directing. It's referencing the design guide, or in this case, the design guide appendix, but there's no active word there in front of it. And I'm not wanting to put words in your mouth about what those words might or might not be, but what was the reason for listing that matter of discretion the way it has been listed?
Commissioner, I think that one's probably more squarely in my camp. Yes. I'm also a little bit wary. I'm going to be careful on how I presented you some evidence on behalf of another client around this topic area, not specific to this example, but more generally. So I'm just going to address this one squarely as it relates to the precinct, and I'll try and steer clear of the wider discussion. The way that one is framed is more consistent with the operative plan approach of simply specifying the design guide as a matter of discretion.
Yes.
Whereas and it's also consistent with how these matters are framed in the city centre zone and other centre zones.
Yep.
Where they are presented differently to how it is set out in policy 6 and 7, I think, with the two references, which
6
talks
and
about
7.
the intent.
Yep. I mean, I just picked that one randomly.
No, fair
The
enough.
Mount Vic character area uses the same language.
The same.
The relevant wording in a non-precinct area where you trigger the need for trigger an RDA is simply the residential design guide, and I'm thinking of R4 there.
in a non,
Well, I presume that's, well, there may not be a non one, but presumably, well, what you tell me, what's the matter of discretion in a non-precinct area?
policy.
Is there no matter of discretion?
That the matter of discretion is the reference to policy, and then in turn, the design guide language comes in at the policy level rather than
Okay.
a matter of discretion level.
Okay,
So there's a little bit of an inconsistency internally in the plan on how that's done.
I understand that now. Thank you. That's interesting.
I can't point you to the exact paragraph reference at this stage. I'll have to have a look, but we have recommended that that inconsistency be addressed in later streams. So we acknowledge that,
Okay.
and we will look to address that in later streams to be consistent with the approach in the residential chapter.
Question has just identified that there is an inconsistency within the residential chapter. So which way do you want to go?
I think we'll need to address that in the right of reply. Also acknowledge that.
Okay. Well, you can see we're just still getting our heads around these idiosyncrasies. Well, can I ask you, Mr. Lewandowski, do you know whether the choice of the language, well, the language must have been intentional, where as it relates to precincts anyway? There was no attempt to put a word in front of the term, the residential design guide, was there? Or it doesn't appear to have been.
Not on my part, sir. So yes, that is an intentional.
Yes.
As
You would have seen plans that might have the words consistency with the residential as a matter of discretion.
yes, I have, and I would. We're going to have to reach a view around this.
Yes.
And something like consistency, like you framed it, I probably wouldn't have an objection. I've got a view around.
Going back to Dr. Zamani's point, it might be consistency with relevant design principles and objectives rather than consistency with all of the guidelines.
Yes.
And it may be that the policy solution might be the way to go. I mean, the reference to the policy as it does with buildings outside precincts that trigger the design guide.
Yes, indeed. And I don't want to switch hats on you, but there's an issue around that intent of as well. That
Yes.
You've done design guides to death. Dr. Zamani, I wonder if we could shift focus. Mr. Ray for Kaingora has given us about 20 pages of rezoning maps. And I'd like to know what your view is on each one of them. Because I'm not suggesting you chapter and verse, but from an urban design perspective, I want to know what the council's response is to Mr. Ray's recommendations. Like there's a planning response, but as I want to know what the urban design response is. And the problem for you is that I need to know that before I talk to Mr. Ray on Friday. And I think hopefully Mr. Lewandowski's gone off to find a copy of Mr. Ray's evidence, because genesis for this request is, as I said at the outset, Birch and I tripped around the town looking at all of these areas, forming our own view, which is incredibly bad practice from a commissioner perspective. And so I don't want to be relying on my impression of the design attributes or urban design qualifications. I want to rely on your advice and Mr. Ray's advice and any other expert who shows up with qualifications to give us an expert opinion on these issues. So some of them we can probably take as read because they're a consequence of the walkable catchments, like the Johnsonville rail line. But Mr. Ray suggested whole around all of the local centres and And I suspect we'll only have to look at a couple of them before we'll get the drift of your response, and there'll be, and most of the rest will follow. So it's a big curveball. So
That's not a problem.
we just need to get.
Unfortunately, yeah, exactly. I don't have access to those maps.
Do you want to?
And if the answer is that it would be better for you to go and study them and then come back and tell me, then that's fine.
I was just confirming that Dr. Zamani's here tomorrow, and
Yeah.
so studying them this afternoon once he's no longer being questioned, and then this evening and coming back tomorrow and representing at that time would probably be the best way to deal with that, so that you have his answer before Friday.
So happy with that. At the next.
Before, is there any specific areas, considering that probably there's quite a number of them, is there any specific areas that you would like me to study them specifically?
Like effectively, Mr. Ray is suggesting different height limits in different locations with reference to the central city zone, reference to the local centres. So you don't need to worry about the railway stations because we did that in Street 1. So it's not those, but it's more the logic. Like from an urban design perspective, what's your reaction? Like I'm not saying asking you to look at individual streets and say, well, no, that height limit doesn't make sense on that street because there's a hill or because there's a hole or a gully, but it's more the overall impression. This sort of, is this all just too big, or are there good reasons why it shouldn't be this high? It's those sort of issues that we can look at it. As I say, we looked at it when we thought it was interesting, but I need an expert commentary. So we'll throw that time bomb in your lap, or I will, and. But as I say, you don't need to worry about the ones on the Johnsonville line, and indeed the ones on the around the Tawa Valley that are related to the Carpentry line. Just all the others. For a number of them, I think the sort of like 20 pages, 24 pages. Final appendix. What? It's the final appendix of Mr. Ray's evidence. I think it's appendix C. The other urban design question I have for you is, can you sort of stand back and tell me the logic from an urban design perspective of the height limits in the plan, starting in the central city and working out sort of like we know what the height limits are, but what I'm interested in is from an urban design perspective, what's the logic that underpins them? Why is 6 stories appropriate in some places and not in others? Like it may not be solely an urban design issue, but to the extent that it is, I invite you to tell me. So starting in the central city.
I will take you through some of the rationales of general different height considerations that we had, whether they are in the central city or centres or residential areas. And these are the matters that I've considered in consultation with the district plan team over the last 2 years. The first one, I think, is the general urban form of an area and the context that height overlay basically is applied to. For instance, the central city generally have higher building. Of course, there's the expectation that it's the center of the city, there's the heart of the city, there's businesses and commercial activities, and also from multiple from climate change point of view, from accessibility point of view, it makes sense to have higher height limits. We had a number of conversations around not having a height limit in the central city, and the reason that I supported having some level of height limits is probably relates not probably, definitely. I believe it relates to the topography of Wellington, wind, and morphology of Wellington. So Wellington has really narrow streets, considering the geographical limitation of being like the central city being a squeeze between the hilly topography from one side and the ocean from the other side. It created a very limited area that resulted in a very dense urban environment with narrow streets. Having really tall buildings above, especially in Tiara, that we have 42.5 height limits, that would result in basically what we call the canyon effect, wind tunnels. We would end up with having streets that they fully shaded 24/7 through the whole year, which is not ideal. I understand with increasing the height limits, you would lose some of the sunlight, but ideally you would not lose all of the sunlight. So that was a consideration that I had when we discussed the height limits in the central city, different parts of the central city. In certain areas, we already have taller buildings, so it's expected. And again, the form of the city provides some relief in certain areas to have higher building rather than the others, while, for instance, Tiara is relatively flat with narrow streets. And again, having higher height limits would have resulted in losing not only amenity, but a lot of urban qualities that we have in the area, not really achieving good urban outcomes. Some of this logic applies to other centers. Of course, when you get out of the central city, the complexity of interface between character areas, heritage buildings, transport routes, they all have an impact on the way that as an urban designer, you would think about the height issue, proximity to the central city and proximity to the centers. Again, from an urban design point of view, having the transition from really tall building to smaller building, again, with the context of the topography, would make a lot of sense. For instance, in Newtown, again, Newtown is between the two sides of town belts. So that's a consideration. And as you can see, there's a higher height limits within the spine of Newtown, and the further away that you get away from that spine, you would have lower heights that would help with the sunlight access, general urban form, walkability, access to transport, and access to other amenities like medical centers, schools. And these principles, I confidently can say that apply to all the centers. There has been a lot of discussion with myself and my team around the impact of different height limits on residential amenity, including the high density residential and medium density residential. We have done modeling to understand the impact, both from urban development point of view, but also from the impact on the amenities of the future residents of Wellington, but also the neighbouring residents. I believe that the height limits that we proposed in the proposed district plan was appropriate in terms of enabling development to an extent that we are required without compromising the amenity of future residents and the current residents, and achieving good urban outcomes. In many cases, because of the specific characteristics of Wellington, including the size of the lots, we would feel that, for instance, the combination of different standards would lead to a worse urban outcome and also less urban development. Therefore, my suggestion has been, and again, you can probably see some of that in the joint witness statement with Mr. Reed. I agreed on some of the higher, more relaxed kind of height into relation boundary recession planes in order to achieve more urban development without having an impact on urban quality, basically. I'm not sure whether that would answer all of your questions regarding the height.
Start.
Probably one more.
So when you say a combination of different standards as to where's outcomes, so obviously you've gone for consistent standards, but only to a point, because there are exceptions that Mr. Patterson's already pointed out. So what's guided you in terms of the exceptions?
Apologies, I don't know which.
Like for instance, there are, just pointed out, there's a general 11-metre height limit, but there are areas that are 14, and similarly, there's a general height limit of 21 to 22 metres, and the HDZ, which is also varied. And so what's guided your thinking in terms of where it's appropriate to have, if you're seeking generally for consistency, what's guided your thinking as to where there are exceptions?
So from an urban design point of view, when I isolate an urban planning matter or standard, I believe that these standards will not, by themselves, will not have an adverse effect on the urban environment. It's a combination of them that can lead to adverse effects on people and environment. So for instance, they increase the height from 11 to 14. I don't believe that increase in height by itself will lead to adverse effect. Is the combination of other things that from that jump from 11 to 14 can lead to adverse effect. In many cases, I believe that from that change from 11 to 14 wouldn't result into any adverse effect. It actually may help not only with increased capacity and urban development, but also for better framing of the street. You have basically from 2 floors to 6 floors, you still can maintain human scale and human connections. If someone is standing on a balcony, you can still see them. So there is those kind of material urban design, quantifiable material urban design matters that you can say they're applicable. So in a lot of cases, the compromise or the exceptions, I believe that doesn't lead into any adverse urban effect, if not to actually make the urban environment better. I'm quite happy to clarify if there's any other exceptions.
What else I had? Just going to go now to. Oh, you go.
Sorry, Dr. Zamani, I'm just trying to get my head around what you've just said, and I think I understand what you're saying. This is an important piece of information from you. You know, there could be a lot of work involved, and so you've given some homework by the end of tomorrow. We'll also hear from Mr. Ray later in the week, and we'll be questioning him on his 24 maps and how he's arrived at the different height matters and the zone boundaries. So, and we need to do that to test the evidence, and that'll give us a feel for the robustness of that evidence. At the end of the day, unless we have something from you that challenges that, following that robustness exercise, we may only be presented with one set of evidence that's suggesting an increase in height. So this is your opportunity to tell us why the heights that are being suggested in Mr. Ray's maps are not appropriate. Specifically, I've noted down the general themes about sunlight issues, transitional reasons, general urban form, access to services and amenities, and that you've adopted those principles. You've taken the government's instruction of at least 6 stories. Mr. Ray, in his evidence, is just saying he's done the same thing. He's taken those matters into consideration. He's ground truth the matters through site visits, and he's taken the direction of at least 6 stories and taken it to what he thinks is a logical extension to providing for a range of heights and identified spatial areas ranging from 21 metres right through to, gosh, I think 43 in one case, 36 in others. So we need to understand how he's arrived at that, but we also need to understand why you disagree with him in relation to specific localities.
Yeah, the Commission's right. Well, I said we didn't need a street by street analysis. We need a pretty detailed response. That would be the message.
I mean, you said you'd done some modelling. I just quickly wrote that down, modelling on the impact of height limits. I wasn't sure if that was in relation to the height limits that are suggested in the national direction, or whether they were height limits over and above those. So that's another issue that needs some clarification. I don't need the answer right now, but what modelling you've done and where it appears and how it fed into the Section 32 analysis will be important to know.
The statement that I made around the increase in the height wasn't necessarily an approval or support of Mr. Ray's maps, because I haven't seen them. And what I'm trying to clarify is that increase in heights by itself, I don't see a problem with that. The problem when it becomes problem is when you put it into context and specific sites or street or urban fabric, and that increase in height can be quite problematic in terms of the effects on the neighbour or generally the effects on the urban environment. And without seeing those maps, I cannot comment on it. But for the exceptions that I think is in the proposed district plan or section 42A, I felt that they're appropriate because I didn't feel they would have any urban design, negative urban design impacts.
Okay, we'll take that as given and that out sometime tonight. You're probably buffering and cursing about the task we've set you, but it goes with territory, I'm afraid. I had a much more specific question relating to your paragraph 40. It relates to minimum size standards. And there's a comment right at the end saying what's in the district plan is already lower than international standards. And I'm thinking to myself, okay, what international standards and what do they provide?
I don't have the numbers on top of my head, but I have done a lot of research on the minimum standards for floor areas of residential units. I can provide that for you.
Thank you.
From that, you know, okay, they're different, but what's the reasoning about why?
The reasoning for the difference between the international cases and the proposed district plan. I think a lot of it probably relates to the general construction industry in different countries. In different countries, they have different capabilities, and I think a lot of it, again, probably is not a strictly an urban design matter, but I think it goes back to the market and the business models of construction industry in different countries. For instance, with a 1-bedroom unit on a 40 square meter, it may be a profitable proposition in Ireland, may not be here, depending on the price differences.
Yeah,
Okay. Mr. Whittington, I just picked up, and I should have asked you at the time, Dr. Zamani, but Dr. Zamani said he hasn't seen Mr. Ray's maps. Now, they were provided on the 17th of March. There's an opportunity provided by the panel for rebuttal. Dr. Zamani hasn't availed himself of that opportunity. I don't think. There has been some joint witness conferencing. I've had a look at that in relation to height, and to be honest, it raises more questions than it provides answers. I'm thinking of issue 6. Not trying to be critical, but the agreed positions under 5 to 9 really need a lot of questioning to understand where the two witnesses have got to, because I can't tell reading between the lines where they got to. So
Well, that was going to be my next question.
yeah,
Next line of inquiry, Commissioner, to ask Dr. Zamani to take us through the joint witness statement.
yes, but I guess I
where that
only
led.
use the joint witness statement as an example
Yes.
of why there wasn't any rebuttal in relation to Mr. Ray's evidence in the timeframe that was provided by the panel.
Look, I don't know that I can answer that question right now. It's something I'm going to have to talk to the other council parties about. In terms of the joint witness statement, again, that's not something that I've had any role in doing anything other than reviewing it once it was filed. So
Forget about the JWS, only used as a surrogate for the absence of rebuttal. But as to why there wasn't any, I'm just intrigued.
Yeah,
and
well,
except you probably can't answer that. But
no, it's something for me to explore with the team as well. Thank you.
So, having said that, ask you open the joint witness statement and talk us through what you've agreed and what you haven't, Marty. Some of it's obvious, so we take.
So the issue number 1 relates to medium residential zone S1, so MRZ S1, and the increased height from 14 meters to 18 meters. And the second matter was increase of 5 meter to 6 meter as a starting point on the boundary of HIRB control in areas where the increased height standard applies. I had no problem with that, and I considered that, and I found it appropriate to do that. Again, from an objective urban design point of view, there is no issue with this. There may be other planning issues. That's not within the scope of my comments.
So you have no issue with pushing those height limits from 14 to 18?
No. The second issue, which relates to issue number 5, and I would like to discuss them together, so I will escape issue number 2. Issue number 2 and issue number 5, they try to achieve the same outcome, and we spend most of the conferences discussing that. Issue number 3 is the boundary setbacks in medium residential zone. I did not comment on the site setbacks, boundary setbacks in this basically issue, but there is if you go to the next issue, issue number 4, I think we discussed the boundary setbacks extensively there. We agreed that the S4 boundary setbacks as per section 42A report is appropriate for medium density residential. So probably this is where some of our differences in our urban design assessment kind of appears. The first one was the inclusion of 1.5 meter front yard setback as a standard. I do not believe that needs to be a standard. I think that's a design matter, can be discussed through the design guides. In many cases that result in a not very good urban outcomes. You end up with leftover spaces in front of a building. There's either fenced off that leads to septic issues or is used for storage of unwanted things or rubbish bins. So I've seen not very good urban outcomes out of that standard, but at the same time, I understand it's that 1.5 meter used for landscaping and the transition between the public realm to private realm, which was Mr. Ray's kind of point. It can be used as a kind of a good standard. My problem was more around whether this needs to be a standard or it should be a design issue. I believe that needs to be a design issue rather than a standard.
So would the standard be 0?
Yeah.
No setback?
No setback. And if the applicant or the architect decide that they require transition space, depending on what's the use inside the building or the specific rooms orientation, or requirements of that dwelling, then they can include setback as needed.
You would accept that if the development applies with all the standards, there'd be no resource consent and there wouldn't be any assessment on the merits. There'll be no process for the assessment on the merits.
No process for assessing the design merits.
Yes. You'd accept that.
That is
Yeah.
correct.
Okay.
I believe that there is more merits in not having 1.5 meter setback
Okay.
as a standard.
Understood.
And I think where we agreed on is 1 meter side yard setbacks. And we did agree that would be the waste of land, and it will be a leftover space that is shaded and not very pleasant place. Therefore, we don't believe that's needed. Issue number 6.
This is the one I had the most trouble with, just getting my head around, Dr. Zamani. Yeah.
Number 6. Okay. The first agreed position was increasing the 21 to 22. 21, that goes to a very practical point that I will try to kind of unpack as simply as possible. When you have a height limits that matches with the exact number of floors that are required, for example, 6, and if that height limit is on the edge, that results in architects doing what we call pancake buildings, is basically reducing the floor to ceiling height in order to fit as many number of floors under that height limits. Of course, from 21 to 22, you cannot fit another floor, but you can increase the floor to ceiling height, which results in a way better kind of urban living environment for people.
Just out of interest, Dr. Zamani, what's the typical or accepted industry standard for the floor to ceiling height?
It really depends what kind of a market we look at. For more affordable, cheaper side of things, it's 2.4 because that's the size of a chipboard, and 2.7, 3 is ideal, but we barely get that.
So there's a range. Yeah.
Yes.
Yeah.
I mean, it's kind of unfortunately chipboard size defined.
Yes, but you're confident there that another meter isn't going to enable a very small floor to ceiling ratio be achieved that would result in an additional floor that won't happen through the additional meter.
Optimistically, it would give the architects to consider that. So instead of forcing them to fit those number of floors within that height limit, they would have the flexibility to provide higher quality living environment. The point 6 within the agreed position is around enabling height in a specific parts of the city, provides more opportunity for high density residential building and location around city center, metropolitan centers. So the whole statement, I do agree with that, and we agree that's a good thing. And I think probably universally urban designers agree that higher density and higher buildings are more appropriate around centers and metropolitan centers. This number 7 is around the stepped approach. Again, I do believe that's a universally accepted method to either increase the height limits by 1 or 2 floors or reduce it depending on the context. So basically 6 floors, 8 floors, 10 floors, and 12-story opportunities. So number 8 is around basically suggested heights by Kaingora. As I mentioned, I do not believe that the increase in the height by itself is an urban design issue. However, if that's accepted from a planning point of view, I would like to reconsider whether we have enough urban design guidance in terms of design of those buildings, and that was the agreed position.
I suppose the key question might be from a and process point of view, you're not going to get a feedback loop. We're not going to tell you whether we agree with Kaigora's height or about anything else. We certainly have made up our mind. I suspect we won't have made up our mind at the end of the hearing until we've sat down and deliberated and talked about it, at which point it'll be too late to feed in, have another go around on the design guides. So one thing is, like, if you think that the design guides would need review in that instance, I think you need to tell us on a contingent basis what changes would need to be made.
And just further to that, and sorry, I'm only just catching up. I'm just trying to relate what you say in paragraph 6. Sorry, paragraph 8 to what Mr. Heald's put in his track change provisions, and that's on page 36 of Mr. Heald's evidence. It's in his appendix, and you've no doubt seen that. Okay, so that's standard 1 for the HRZ, and so that, I mean, it's a 22 metre height above ground, except that it can be extended to 43 in structures that are located within 400 metres of the CCZ, 36 within 400 to 800 of the CCZ or 400 of the MCZ, and 29 when it's another certain distances from other zones. So those metrics are ones that you can support.
That's correct.
Okay. Thank you.
Excuse me. Just going back to your issue 1, where you're saying you agree that a change from 14 to 18 meters were identified in the planning maps. Are we talking about the planning maps that Mr. Ray has actually issued with his new heights, or is that the maps that are in the PDP? Question number 1.
I believe these are the maps that Mr. Ree provided me.
He's shown where it's going from 14 to 18.
Yeah, okay, yeah, that's fine. Just wanted to clarify that. What I then would like to ask you is, have you assessed what that change, what impact that change will have in an urban design matter as an impact? Because you were saying before that height alone is not an issue for urban design. It's actually the combination with all the other things that actually make it, or potentially make it, a problem. Have you actually assessed how those 18 metre, those 4 metre increases of height affect that urban design?
By assessment, do you mean shading assessment or the urban form or morphology assessment?
All the things that you told us before that have actually an impact other than on urban design, other than just the height.
No, I haven't done since I've seen Mr. Ree's evidence. I haven't done any assessment purely because of the time, but I do not believe the extra height and extra areas would have any adverse urban design effect. I'm not anticipating that, but I haven't done any specific urban design assessment on those specific sites. And the reason that I believe that's not necessary, because these kind of development would require an urban design assessment, and I think the residential design guides or centres design guides would apply to it. So therefore, we can manage those effects of that extra height accordingly, depending on the context. I do not believe that increasing the height on area around the local centre would by itself lead to any adverse, it may lead to other urban planning adverse effects, but not urban design effect. And if it does, again, that become a case by case, site by site assessment based on the residential design guides and centers design guides or the design guides.
So do I understand you right that you rely in that aspect on the design guides and the necessity to be assessed against that, that will eliminate any negative effects that might come out of the increased height?
Absolutely, and again, I want to make that disclaimer that you may have other urban planning issues, and I expect that will be dealt through basically my colleagues in the planning aspects of things. But from an urban design purely urban design point of view, I do not believe these increases in the height would lead, because if I say it does, I need to prove that it does, and I cannot do that.
Right, thank you.
Just giving you a moment of just to pick up the Mr. Heal's standard that you agree with.
If there is no other questions, I can go to issue number 2 and 5.
Yes, it would be good to address those. Thanks.
So the issue number 2 and 5 are related to a very common urban design issue that is referred to as how urban designers can basically advocate or encourage a primitive block type development. And so that's the bottom line of the issue, basically encouraging the buildings to be built to the front of the sites with a backyard at the back or a courtyard at the back. And there is differing kind of views on terms of how to achieve that. And there is a big intersection between the planning side of things and the urban design outcomes that we want to achieve. One of the common methods is inclusion of HIRB of higher height and a basically open degree. So basically opening up the site into higher development potentials to achieve that height that is required rather than tighter angles to stop the development or lead to basically stepped approach to the building. And this needs to be applied to the front of the site with a 50% site coverage that leads to hopefully a backyard. So issue number 2 is about inclusion of these HIRB, and I do agree with that. That's a good thing because that encourages the building to be built to the front of the site. Potentially can lead to better outcomes. However, I think that's where Mr. Ray and I kind of differ, is that I do believe that's not enough. And that goes to issue number 5, that Mr. Ray believes that we shouldn't have maximum building depths and minimum building separation. We should only have the HIRB 19 and 60 degree kind of aspect. The reason that I believe that only having the HR kind of laxer or more relaxed HIRB at the front of the site and nothing else is that you still can end up with having what, again, a very colloquial term in the urban design realm is the sausage buildings, the building that goes to the length of the site, facing the side boundaries and facing the neighbors. Both these standards try to avoid that by pushing the building to the front and providing a backyard rather than having a driveway to the side and a side yard facing the neighbor. I do believe that the minimum building depth is required to make sure that the building sits in the front and the backyard is actually at the back of the building rather than the side of the building. Mr. Ree argued that this would limit the development, and I do agree with him that it does limit the development. That's the intention, to make sure that we reduce some of the bulk and dominance of the building to create a relief. It would have better environmental impact as it enforces more permeable spaces at the back of the building. Eventually, it will lead to a bit an urban form, as we've seen in many international case studies. And even in New Zealand, we have perimeter blocks. The center of these blocks lead to basically having more communal gardens or even private gardens that lead. There is so many proven benefits to this approach. I think the question is that how do we reach to this outcome? I think Mr. Reed really understood where I come from. He just believes that there's limit the development potential, and I do agree with him on that front. But I still believe that we need the building depths and separation between the building, so we don't basically cover the entire site with a very long slab.
Despite the clouds that would be nourished by the addition of a 50% side coverage that might have long-term sausages, but there'll be some space between them.
That is correct. And the problem with that, those sausage buildings, they would have 50% or maybe even less site coverage, but that 50% that is not covered is normally driveways and very undesirable side yards facing the neighbor. While having backyards or communal courtyards is very more desirable outcome from an urban design point of view.
We done with Dr. Smiley? That's good, thank you.
Thank you.
I apologise in advance for the homework I've sent you, looking at these boys' maps, but so you get the big jobs.
No, thank you. Cheers.
How do you want to proceed? Do you want to call Ms. Curl now? Or
Happy for that to happen if that's.
okay, we have been hear from her.
Okay.
Cool. We've read your evidence in advance. Is there anything you particularly want to highlight before we ask you some questions about it?
Kia ora, no, I assume it's taken as read.
Okay, if you,
Is it on? Yes. Yeah. No, I will assume it's been read, and I'm open to questions.
thank you.
That jumps out at me at the moment. In your paragraph 20, you are describing under G31 that this requires the designer of the applicant to consider how residential development will respond to adjacent heritage buildings with regard to scale, regardless of whether the heritage design guide will be used or not. In my view, this guideline should remain as written. Now, I'm wondering, since the design guides and the introduction, which sits over all of them, they need to be considered anyway. Is that double up in terms of having to look at both things.
Just to clarify, you're asking, is there a double up between the residential design guide and the heritage design guide?
Yes, in the end, because you're looking on the one hand at the, as I understand that, if a development is adjacent to a heritage building, that might not necessarily be in a heritage area. That could be the normal MDZ. So that would actually fall under the normal design guidelines. But then we have on top of that the heritage guidelines. So I understand that right, that you need to, in that case, you need to read the introduction. You need to look at the residential one, and you need to actually comply with the heritage one.
It would be my understanding, and the reason I've said it should remain as written, is that sometimes the heritage design guide may not apply, but there may be a heritage building adjacent, and then you would consider the scale of that building. And that would be the only consideration needed to be given.
Only in terms of the scale.
Mm-hmm.
Okay, great. Now, with regards to designing with topography, your number 18, I'm sorry, I'm jumping around a little bit. G12 and G13 are integrated. No, people ask for them to be integrated, and you are saying that doesn't need to be. Can you talk me through exactly what your reasoning is there?
Yes, 1 second. I'll just read the guidelines. Okay, so G12 is referring to when changing the topography and landform of a site, mitigate the effects of stormwater runoff. That's saying if there's earthworks, consider that it may cause more stormwater runoff or less. G13 is saying that when you're doing earthworks, general landform should be maintained to minimize the need for large retaining structures. Design any required earthworks and retaining walls as positive landscape features. So that's when you're doing earthworks, you should consider the retaining walls. To me, these are two very clear, different design outcomes. One is about water, one is about retaining earth.
Yeah, I thought as much, just needed to clarify that. That's it from me. Thank you.
Commissioners, any? Starting paragraph 16. Open question. Do places have a whakapapa? I know people do. Do places?
Yes, it's my answer to that question. The word whakapapa in some translations means to place in layers.
Say again.
It means to place in layers, and the word papa is the ground as well. So my answer is yes. But it's a question that could be deeply philosophical, I think, as well.
Okay. Talking about paragraph 21. said reference to G39. So where possible, have step-free entry and then you have G33, where possible, provide ground level access that's accessible by people using wheelchairs and design units. Isn't that, well, presumably with reference to NZ standards for access and mobility, presumably those standards don't include steps. Since like I have seen exceptionally fit and healthy, one in particular, people in wheelchairs get up steps, but it seems like that seems to be a duplication. Like that, no steps would seem to be a subset of G133.
I agree that it could be assumed as a duplication, but 133 specifically for designing for accessibility. And G33 is designing generally to reduce the steps into a building, which can encourage general accessibility.
I think the general concern from the submitters is that
There's too many.
there are an awful lot of guidelines here, and I think Mr. Patterson's answer was you've considered them and you think everything that's left is now essential, and you're thinking, well, I think that maybe you need to have a second look. That's all I'm saying. And the other example, well, is reference to external storage, G99 to 103. So we have large development, secure weatherproof storage area to store bikes. It should be accessible from the main entrance. That's 103. Where possible, locate them near to primary entrances. Bike storage should accommodate electric bikes. It all seems a bit OTT to be addressing all of these instructions as to how and where bikes are to be stored. Is this a level of detail that the council should be sticking its oar in quite so much?
I would agree there's probably further rationalisation we could do ad nauseum to these design guides, and trying to seek the optimal written design guide would take a lot of time. We have done what we can in the time given over the past few years. But the reason we haven't rationalised some of the design guidelines is that some of them may be applicable where others aren't. So there are very specific design outcomes we are seeking through each guideline. And as mentioned earlier in the day, if we were to rationalise and sort of conflate the design guidelines into one guide, we then have to provide further assistance to the applicants and point them towards one sentence within a very long guide, rather than just provide them with a short sentence in one guideline. There's pros and cons to both approaches.
And the last point I wanted to ask you about was something specific, and Mr. McIndoe colleagues' evidence. This relates to paragraph 32, service elements. He's basically saying, well, the only way you could satisfy that is if you've got a detailed internal design, which you won't have at the point where you're seeking resource consent and approval under the design guide.
Sorry, can you clarify which guideline there?
Paragraph 32, it's about 96, G96. That's what you've recorded it. Hemmer's talking about. I haven't gone back and checked what he was referencing.
Yes. So the answer to that is for larger developments such as large residential apartment buildings, we do receive high-level floor plans, which include where the transformer will be located. And that is something we usually need to discuss upfront in pre-applications because generally, in my experience, not enough space is given to that. And they end up with a much larger plant room needed for that type of utility, which takes up a large portion of the street frontage and affects the urban outcomes of the street frontage and of the entryway into the building and wayfinding. So we do comment on high level things such as location of those and the size that should be allocated. They will be resolved in detailed design later in the consent or through building consent, yes.
Oh yes, I think it's now this. I think it might be near G98. Appliances and fixtures for dwellings should be placed at accessible heights and locations. Sorry, I'm just rereading it. I think that was the focus. You're to put appliances.
Yes, for the submission, it seemed there was some confusion about what plant fixtures were.
Yeah.
And so we created an additional guideline to address what we perceived the concern was that consideration should be given for accessibility to appliances within a residential unit, such as perhaps like a hot water cylinder or your dishwasher and things like that, which was separate from your roof plant, your transformer room and things like that.
But in terms of the guidance you were given, that I think that might have been the point Mr. McIntyre was making. If you're going to say, well, where's the dishwasher? That means you've got a detailed internal design of your kitchen, presumably detailed design of your laundry fixtures. Are you going to have that? And at the point when somebody's making a resource consent for, well, you said large developments will have that, but what about a small development that or like a four unit development that hasn't done any internal design? Are they going to get bounced out because they can't show they meet this?
No, all applications are case by case basis. If an applicant in this instance were saying they were proposing accessible units within a residential building, then this is where this guideline may become applicable. Is there room for rewording this guideline to reflect this case by case basis and flexibility? Yes, possibly.
Would it be sufficient to indicate an intention to do that?
Can you define how they would provide an intention to do that?
Well, if you say on if the design, if you have a broad design that doesn't include detailed internal design and a covering statement that the internal design will, like other things, achieve these outcomes.
I'm taking a moment to think because this is a new guideline we added in response to submissions. Usually, if we were looking at a specific design concern within an application, we would consider requiring a higher level of detail for that design concern, such as external lighting in a large development. So I would say if someone were providing accessible units, we would probably want to know the internal layouts as a general idea. But I think, is it possible that I can come back to you on?
It certainly is, like all of these things, we're like, I'm not asking these questions with the thought that you would necessarily agree with me. I'm putting a proposition and say, inviting you to think about it. And if your answer is that you'd like to spend some time thinking about it, well, that's fine.
Yeah.
Like, that would be the case, and unless we have a specific requirement that we need to know an answer so we can put it to another witness or one of the submitters, then it's certainly as a general principle for all of the counsel's witnesses, that's the case.
I guess there is an issue, first of all, with the internal, and you're saying that you would actually ask then, in that case, for more detailed interior layouts. Now, an interior layout is not necessarily defining the height of an appliance for a start, so you wouldn't get the information that you're asking for here. The other thing is, as an architect, I can tell you not every impaired person has the same requirements in terms of height of appliances, because that depends on the impairment. So does it make sense in that case to have that in there at all?
I think I would like to come back to you as we have had time to give all of the other guidelines that we've used to date consideration for how they would be implemented. And with your concerns that you've raised, I'd like to consider it. And
Any more for any more?
Just one, I noticed through the course of the hearing, we've been asked to change the language a little bit, and 98, you've got a disabled person. I think that one of the submissions has been asked that we use person of impaired, impaired person or something like that. I can't remember what's come through on the submissions now, but we could just have a look at that too.
Yeah, refer to impairment of disabilities.
Impairment, not disability, ability or impairment. This language.
yes, thank you. Just to confirm, is that G98?
Just in G98, but there may be other
Yes.
areas in the design guides that it may have been used.
Global
so
search
it's
for the
just
word disability might be a good idea.
I'll search for ability.
Ability, yes.
It's ability or impairment. Disability is again a different thing.
Yes, but yeah, she'll need a search. Thank you.
Thank you, Ms. Kerr. Appreciate your input. I think we're ready to talk about the nitty-gritty of the residential zone rules. Patterson, but before then, some of us need a cup of tea. We'll take an adjournment for 15 minutes, so we'll come back. We'll aim to come back at 25 to 4.
Commissioner, before you run away, I've just received the maps you requested earlier in respect of Mount Victoria Historical.
Oh, that's great.
Society. Would you like those distributed via?
Yes,
Darren?
please.
Thank you.
We'll adjourn back at 25 to 4. Thank you for that. Organising that, Matt. That's very helpful.
Having just looked at them, sir, you could probably discard one of them, which is the plain grey.
Figure out what the difference between these two.
So just to talk very briefly through that, they all show the same, or two of the three show the same information. One has cadastrals, one doesn't. The one without cadastrals you could probably just discard briefly, but I just forwarded them on as I received them.
Jensen, starting on the stream 3 report. The plan we start with that or go to the character part.
No, I'm happy to start there.
Same approach, commissioners. My first question is on page 4. Talking about Mr. Osborne's evidence, page 19, paragraph 19. Support the
Apologies, Chair. Are we on part 3 or part 2?
question, part 2.
Part 2.
Yeah, HRZ. The in terms of how much surplus we have in the residential capacity assessment. Stream 1, Mr. Osborne told us he hadn't considered existing deficit. He responded and suggested that he doesn't agree with Mr. Cullen's estimate that will be 10,000. He says Mr. Cullen misread the relevant table. I understand that. But Mr. Lamb said what his view of the existing deficit is. So does that create a loose end in your analysis? You don't know what the existing deficit is. Okay.
Yeah, just thinking about that one. I don't think I'm going to be able to come up with a satisfactory answer off the top of my head, so we'll have to look into that a little bit further.
So is the we asked Mr. quantify his view of the advise his view of the deficit. We're waiting for that reply. That is due this week, I think.
Okay. Might be appropriate to wait for that reply.
You approve the answer out there.
Can I just clarify? So I recall the discussion you had with Mr. Osborne and his indication that he would go away and look at that. But in the question, it sounded like you said you'd had a reply from him, or was that the reply he gave you orally?
No, the point being that in Mr. Patterson's supplementary, he has attached some commentary from Mr. Osborne.
Okay.
Cullen's reasoning.
Right.
Which I suspect we will get back in stream 1 reply.
Yes. Okay. I will.
As well. Hopefully, Mr. Osborne will also tell us what his opinion is.
Yes.
But that's an open question. So it might not be as flash as you're presenting. Paragraph 41, increase in traffic. What's that? I'm up to paragraph 41. Any advance on paragraph 41? Sorry, thank you, Commissioner. Go for it.
Paragraph 23. 23B states enabling housing supply should be a priority over character protection in identified character precincts. Now, have we, and again it comes down to numbers, I think Mr. Osborne has a lot to do. In what capacity can the character diminish the housing in terms of that? While there is at the moment certain houses that have a primary or a contributory status, and they are of course having to go through a demolition consent if they want to rebuild that. I would assume that buildings who don't have that will go through the process as well, but it will be just a tick box exercise, because if they don't add to the character, then they could be demolished. So now you've got on the one hand, you've got the teeth in between that might come out. Has that been taken into account in terms of the capacity? Because if you take those teeth out, where there is at the moment one dwelling, if you take that out and you put a medium density building there, that will be more than one dwelling. Has that been calculated on how much the character really diminishes the intensification?
I think this is a summary of what the submitters are saying rather than what.
Yeah, but that's what they are saying. But has that, to answer the submitter's question, has there an analysis been done on a side-by-side basis, basically, if there is 16 different non-contributing parts in there, then there will be a certain development capacity. Has that been added at some point in time, or has that not? And it might be that Mr. Osborne needs to answer that question, because if we want to get real numbers, or when I say real numbers, that only happens if the thing will actually be realised. But in terms of the overall numbers,
That might be for Mr. Lewandowski.
Well, it may be for both of us, and Mr. Patterson certainly has a greater familiarity with the capacity modelling than I do. The starting point of the model, though, is that it models, as I understand it, permitted development. So because you have no level of permitted development within the character precincts, the starting point for the modelling for those areas is 0.
okay, yeah.
The actual reality of that is that there likely is some development capacity in there, greater than 0 certainly, but because you have to make a number of assumptions about that, you get onto pretty tricky ground. So it's safer to count them as 0, but acknowledge the fact that through a resource consent process, the reality of that is quite different.
Acknowledge that that's a conservative assumption.
Yes, absolutely. It's just very tricky to try and pick winners within that and try and ascribe a certain yield to that, etc.
Yeah, but what you've given me just now is what I needed. Thank you.
Any advance on paragraph 41?
137.
37?
I just was interested in your comment saying that loss in amenity for existing properties is not a resource management issue that requires consideration in the RMA.
Well, I think it's the need for compensation, which is the bit.
Sorry, missed that bit. I guess as a general comment though, I struggle with the gap between the RMA and amenity values and where we arrive at now with existing amenity values. So I just wondered if you could comment on how you perceive amenity values under the plan and the gap between the requirement under section 7 of the RMA and the plan in terms of amenity values, requirement, maintenance and enhancement.
The general approach that I consider regarding amenity is that under the PDP it's signalled that amenity will change and can change. And that's certainly been the approach throughout the development of the PDP, and one that I agree with, and is also signalled through the NPSUD. So I think we've acknowledged that and responded to that. Is that what you're asking?
Are you referring to policy 6 in the NPSUD?
Yes, I believe so.
That amenity can change over time.
Yes. Yeah, that's exactly
Is
it.
change a euphemism? Can reduce.
Can reduce. I mean, changes.
What policy 6 says that the urban environment can change, but that will mean that some people will lose amenity and others will gain. So calling a spade, as the question says, section 7 says that particular regard has to be given maintaining and enhancing amenity values. The NPSUD is basically saying, well, you only need to give particular regard to some maintaining and enhancing some amenity values, accepting a winners and losers position.
Yep, I agree with that.
And on that score, when we're talking about section policy 6, about to make an unfounded accusation that Commissioner McMahon had stolen my NPSUD.
Long enough.
It says that the acknowledgement is that changes to areas associated with intensification, essentially, can improve amenity values appreciated by families, communities, future generations, including by providing increased and varying housing densities and types. Can you explain to me, or will you tell me what you think increased and varying housing densities and types does for people's amenity values?
I can.
Well, we'll talk. We'll find out Mr. Patterson's answer to the question.
Well, I think
We'll ask you, Mr. Wellington.
increasing density intensification can have positive impacts on amenity in an urban environment, particularly around concentration of people and the design of buildings as well, making use of the space. Yeah, I certainly agree that it can.
Well, that's an efficiency issue. It's not an amenity value.
And when you take into account the
The
residential
concentration of people can, well, some would call that some positive amenity value, some would not.
and it's very subjective, isn't it? It's so what I say, not everyone's going to agree with, just as what other people say I won't agree with.
I can completely understand the whole point that there is a benefit in terms of the well-being of people in communities from having houses if they don't currently have a house. That's obviously correct. But is it an increase in amenity values?
I would like time to consider that, and maybe
We'll ask Mr. Wellington.
maybe
to
refer
answer
to
it, but
Mr.
I'll
Wellington,
write this down for a second. What do you reckon, Mr. Wellington?
Yes. Yes is the answer.
It's like 42 is the answer of everything.
I'll just go back to policy 6 because, you know, we and I'm guilty of it more than anyone, but policy 6B is an important policy. In the paraphrasing of it, you can lose some of the nuance. But for example, we were talking about change isn't necessarily a bad thing. And the question you asked was, is it a euphemism for reduce? It's not a euphemism for reduce. It specifically identifies that it may detract, which is obviously a word that suggests some a negative consequence from amenity values appreciated by some people. And you really need to get into the wording. Appreciated is effectively bringing into the concept some subjectivity. It's identifying, I think, the problem with some of our case law, which is that developments have been prevented or declined because it will change the amenity for people in the vicinity or people opposing the development generally in a way that they will not appreciate positively. They value the space, the open space, the outlook that they have, the lack of high development around them, and they appreciate that. What intensification is going to do is it will detract from the way that those people appreciate amenity, but it will improve amenity values appreciated by other people, communities, and future generations. And that's not just the situation of people who are struggling to get into the housing market now will be able to get into it in the future. It's also that some people subjectively prefer to live in smaller dwellings that they don't have to clean as much. I'm a perfect example. I'm a terrible gardener. There is simply no point in me having a garden because it becomes overgrown very quickly. If it wasn't for the fact that I have 2 kids, I'd live in an apartment. I don't mean to say that kids shouldn't live in apartments, but that's the preference we've decided. That's the decision we've made is to live in a place with a garden. But living in apartments with kids can be fantastic. They can get out and walk and scooter and do all sorts of things. That's all about your enjoyment of life, your amenity. And so I don't see it as being a simple question, as amenity is about what's around you, what you appreciate in your peripheral vision while you walk out to your front gate and down the street.
That's interesting. Paragraph 41. Counsel. How does the transport chapter work? Are multi-level or multi-unit developments high vehicle transport generating activity? What is the trigger under the transport questions?
I'm just going to take a look. So in the transport chapter, standard, is it TRS1, sets out what is considered light and heavy traffic or vehicle movements, and that's defined. So light is 200 per day, and heavy being 8 per week.
So is it 800 per week? So
No, 8 per week.
8.
Heavy. Yes.
8
Heavy vehicles.
Yeah. Oh, right.
Light vehicles and heavy vehicles.
No.
Light traffic and heavy traffic.
Yeah. Sorry.
Thank you. There's a certain pause there. We were saying, what?
Yeah.
So is it? So is there no? So it's strictly on a definition of how many of traffic you generated.
Yes.
I suppose the obvious question is, how much traffic does a multi-unit development generate? I suppose that, which your answer might be ask a traffic engineer, which would be a perfectly appropriate answer, but
That's
that
what
I'm trying to feel out, well, to what extent is the transport chapter actually going to control intensification that has traffic effects, bringing multiple cars down narrow hillside roads that operate at one lane whenever everyone's parked down the other lane.
Sure. I think so. TR Rule 2 in the transport chapter says your trip. So any activities that generate trip generation is permitted where compliance with that standard, which I just covered in relation to vehicle movements per day, is met. And where it is not met, it becomes a restricted discretionary activity, at which point you will likely require input from a traffic engineer.
Obviously, a development. How would the if somebody was proceeding on the basis of permitted activity, how would that actually bite? Like in terms of enforcement, like it's one thing if somebody's applying for consent, the council might might be required to be satisfied that that standard would be met.
Mm.
But if they're proceeding as a permitted activity under the residential rules, it'd be, in practice, the thing would be built and then the council would be thinking about enforcement because in fact it's generated too much traffic after the event.
Sure. I think if you consider that permitted activities will result in no more than 1 to 3 dwellings on a site, I consider that at that point the movement of traffic is likely not significant enough to warrant specific traffic assessment. Also noting that there are, and you would have seen the Spenmore Street area, which specifically directs applicants to provide traffic assessments.
Well, we're going to ask you about Spenmore Street because as we tootled around, we drove up the length of Spenmore Street.
Yeah.
And I have to say that we drove up an awful lot of other streets that were a lot hairier from a transport and traffic point of view than Spenmore Street.
Sure.
So we went down Devon Street, which is certainly memorable.
Yeah.
Who was driving next to me was saying, well, I hope we don't meet somebody coming the other way.
Right. Right.
But so we'll come to that.
Yeah.
So your answer in essence is that 3 or less units wouldn't be a problem,
Yes,
and anything else is restricted discretionary, and
Yes.
the council would have control, could require to be satisfied that that standard will be met.
yes.
Paragraph 55, any advance on paragraph 55?
Mr. Patterson, this is the transitional zones that apply to the medium density zone for height controls in the HRZ. So this concept of having a transitional zone between the MRZ and the HRZ, which you've commented on paragraphs 47 onwards, 47 and 49. Probably a question I probably put to Mr. Zamani, Dr. Zamani, but are you saying, based on Dr. Zamani's advice, that the height in relation to the boundary rule is the solution, and that there's no need for a transitional area?
Yes, I believe that.
Okay. So that's for developments that, okay. And what about for developments that adjoin a character precinct? That we just talked about the areas between the transition between the MRZ and the HRZ. What about where there's adjoining high density adjoining a character precinct?
I have recommended a change to the height in relation to boundary standards to apply the 5 metre and 60-degree recession plane boundary on boundaries adjoining character precincts.
Okay, as opposed, okay. So it's the 5 metre and 60-degree different to the one that you've covered in paragraph 47?
No, same.
Same one?
Yeah.
But in the notified view rule, did that height in relation to boundary standard not apply for character precincts?
Correct.
Okay.
Did not.
Understood. Thank you.
Paragraph 55. You stated your view. Well, why? Why is it an insufficient basis, given the priority given to reduction of emissions, greenhouse gas emissions?
I'll just read paragraph 55. I came at that with the approach that increasing intensification in existing urban areas, in my view, will have greater carbon benefits than the demolition or preventing the demolition of buildings would. So stopping the expansion outwards will reduce the need for people to drive into the city, reduce the need for private vehicle use, which will have greater positive benefits for carbon emissions.
I suppose.
So that's a
on what technical basis have you based that view?
Fair question. I don't have any response to that.
Paragraph 56. There is an issue like there is a partway point that Tasmania is recommending a 50% building coverage in high density areas. What are the pros and cons of a rule or a standard requiring a proportion of the remaining 50% be left as a permeable, at least permeable, in preferably landscape?
In relation to paragraph 56.
Yes, indeed. You see. So that on the basis that, as I say, it wouldn't be a limit of density if you've got 50% building coverage for other reasons. And Kaingora agree with that.
I'm not sure I quite understand the question based on.
Like there's two issues here. The first is where the submitters are coming from, which is loss of vegetation, loss of carbon sink, effectively. And the second is stormwater management. I've seen suggestions that a lot of like hydraulic neutrality is all about either slowing stormwater runoff down or retaining it on site, or both. Sort of, if the 50% that's not built is entirely hard stand, it's going to do the opposite. So basically the question is a standard that, like, obviously you couldn't require all of the remaining 50% to be retained because you need driveways, associated access, but a proportion short of 50%, either in vegetation or all else failing in a permeable surfacing. What about that? Like, I don't have it. I'm not carrying a candle for that particular outcome, but what's your response?
I'll try and answer. So there is a landscaped area standard under HRZS 9, which says minimum of 20% of developed site with grass or plants, which can include the canopy. And also noting that the permeable surface area standard that's proposed to be moved to the Three Waters chapter, which will still need to be complied with. And that requires a minimum of 30% of the site area to
Say again, minimum of
30%.
So the answer to my question is it's already there.
Yes.
Go for it.
Just what I think is probably a simple question. The reference to the 21 metre building height in relation to wind effects. My recollection is that in the operative plan that was 18.6 metres. Presumably that's just being standardised now to bring it into line with the new height standard in the HRZ.
Yes, that's correct.
Nothing more than alignment. There's nothing magic about 21 versus 18.6.
To my understanding, no.
Okay, thank you.
In relation to that, you note that you agree that this matter requires further consideration in terms of the wind and the standards for that. How does that affect? How do you see that affecting the heights that are currently proposed and also the heights that are sought by submitters.
I'll just have a quick read of paragraph 60 again.
And it might be that stream 4, as you have noted, might be the right place to discuss that.
Yeah, I have noted that, and I do believe that to be the case. It would be best addressed in stream 4.
Presumably, the use of the building is not going to alter the wind effects, the height, and
That would be my understanding.
just that you're going to have more higher buildings in the centres of that zone than you will in the HDZ. So it's going to be more of an issue.
Yes. Yeah.
So effectively, what you're saying here is there's no prospect in your mind that cut off for a wind consideration to be higher than 21 or 22 metres, whatever, around there. The question is that it might also be less. There might be a case for considering lower buildings.
Yeah, I think it does need to be addressed under stream 4, and I think that it can be addressed in the context of the residential zone. Yeah.
So your point is that the outcome of stream 4 will determine the application in the residential zones. Is that where you're coming from?
Yeah, that's where I'm coming from. Yeah, and I don't feel I can comment too much further on that.
I'm up to paragraph 102. Any advance on paragraph 102, team? This is about 130 Main Road Tower. What use is currently being made of that site?
I'll have to refresh myself on that. So at the moment, it looks like it's got a cafe located on it in a residential house. Residential style house. Possibly people living in it also.
Intrigued by the request that it be named because main centre's a local centre. looks to be so it's the just observe that.
Yeah.
It's building.
Noting that in the ODP, it is zoned out of residential. So the approach there would have been that it's in the walking catchment of the centre, and therefore being a residential zone site at the moment, it's appropriate to rezone it to high density residential zone.
So it's currently next to the centre.
Yeah.
The ODP has it as a residential property.
Yeah.
Wait to hear what the submitter has to say if they hear from them.
Yeah.
I'm just butting in, Commissioners. Do I hear it said that the neighbouring site is commercially zoned?
It's like.
Yes, sorry,
Like it's light pink, whatever, light.
yes, it's neighbourhood centre as opposed to there is a distinct commercial zone, so I just wanted to clear that up.
Yes, it's next to the neighbourhood centre zone.
Yeah.
And they're seeking an extension of the neighbourhood centre zone.
Yes.
Don't know why. Yet. Paragraph 119.
190.
119. General question. Is it correct to call an activity the subject of an RDA status enabled?
Yes, I believe so. It is signalled within the legislation, and I believe it's. I'd have to go back. I think it might be in Schedule 3A, where it signals that restricted discretionary can be seen as enabling, and that's the approach that's been taken there. Is that correct, Mr.
My instinctive reaction is that it might depend on the nature of the policies as to how enabling it is.
I'm glad you asked this question because I can recall a definition or some provision that talked about enabled and may have been in the draft version that talked about permitted, controlled and restricted discretionary, but for the life of me, I've not been able to find that in previous and or subsequent searches. So if you think it's in 3A, that's of interest. Can you help, Mr. Whittington?
Off the top of my head, I can't.
Yes.
I'm saying something similar, but I thought that was in an early draft of the legislation.
Yes. It may not
Which is
have
done
survived.
away with RDAs.
And
Well, so far, as currently framed.
And the new in the NBA.
Yeah.
Oh, yeah, I'm referring to some other, more of a MPSUD document. But I must have been dreaming when I read it.
So what you're talking about is the use of words that then aligns in the rule framework to which activity status it has. Yeah, I've seen that as well. I actually wondered if it was in the planning standards, national planning standards, but I can do a little bit of work on that while we're.
Okay, we should leave that with you rather than going in slow circles trying to remember where it was. Like that, I have been like those arguments about whether discretionary is anticipated and non-complying is not anticipated, and where has that ever come from anyway?
Yeah.
Town and Country Planning Act. Well, only some of the members on this side of the table remember the Town and Country Planning Act, I suspect.
Mr. Chair, on 117.
117.
Yeah, I don't have a question about 117 per se, Mr. Patterson, but it just reminded me that you start off by saying that you agree with WCC that inundation areas are a qualifying matter. That just reminded me we never got into that mechanical discussion about how the qualifying matters work. Maybe now's not the time for it, but just didn't want to lose sight of that.
Yeah, well, it says inundation areas are a qualifying matter, but I think the point here is that the text doesn't need to say that, but it says they are.
Yes. My question's a bit wider than that, Mr. Chair. It's about how do the qualifying matters work? And the distinction between character areas on one hand, and heritage and hazard areas on another. So there was a discussion this morning with the chair about his understanding that qualifying matters would result in the reduction in the intensification of permitted on a site through either height or density. And just wondering how, I'm really wanting a discussion of how that works with the different qualifying matters that have been posed by the council, including the discretionary one, but hazards and heritage.
Or maybe what we want is a list of what the council considers are qualifying matters, and helpfully what it is considered but has decided are not qualifying matters. Because we did discuss what we discussed this morning was whether Three Waters was or was not a qualifying matter.
Whereas character areas definitely obviously are in the council's view, and the evidence for that is that the height and density in the character precinct is reduced from what the medium density residential standards. So that's clearly affecting the intensification. How that compares with, say, heritage and hazard overlays is just unclear in my mind, because in their own right, the heritage and hazard overlays don't change the heights and density, but they add a layer to the consenting process that through the resource consenting process, the heights and densities might change through, well, in the extreme, declining the consent in a hazard area or in a heritage area, or through the increase of a floor level that minimum floor levels that affect the density in some way. So
I think I can answer that in a general sense and provide some specific help, but it may well be that there is that it will help you to provide a list of what is considered to be a qualifying matter and what is not a qualifying matter and what was considered, but generally the council has put in an interpretive sense a lot of weight. That's probably not the right way to frame it, but has, if you look at policy 4 of the NPS and section 77I, it describes a qualifying matter as one which effectively requires the building height or density standards to be changed. The council has decided that something that affects the developability on a site but does not require a change in the planning framework to the building height or density standards is not therefore a qualifying matter. It's not relying on policy 4. It's simply adding a layer to the consenting process.
Okay, that's really useful, and I've almost written that down verbatim. So does that mean that hazard and heritage matters are not qualifying matters?
No, because the MDRS includes a permitted activity standard for buildings 3 units or less, whereas in the heritage and hazard space, it changes that activity status. So it's changing the permitted activity standard for, it's changing not the building height, but it's changing the density standard, or the way in which that's given effect to through the MDRS.
Which ultimately could affect the developability of the site.
Yes.
But indirectly.
Indirectly, yes.
Whereas coastal hazards, or I think the position is that for high hazards,
High hazard areas.
hazard areas.
Yep.
That does affect, again, it changes that they go to non-complying status, I think. So that has again changed the changes the developability, but it also requires reliance on policy 4 to impose it. So the council's process has been to go through the process for hazards,
Yes.
and to go through the process for heritage, and to go through the process for character. But Three Waters, it doesn't change anything about the building or density standards. It's just that you also, if you don't comply with Three Waters standards, need to get a consent for that.
Yes.
But it won't require you to get, it doesn't open up the entire consent, I don't think.
No. An example that came up in Porirua, and I don't know if you remember, it was a discussion around hydraulic neutrality, which might be a subdivision standard, but it might be in the Three Waters. Is it in Three Waters?
Three Waters.
Yeah. And if the requirement is to achieve hydraulic neutrality, having the same post-development outcome as the pre-development, that in itself could affect density, height, and building height and density standards, couldn't it?
It could, but it's in the sense that a person could choose not to build to the permitted level.
Yes.
Because, build beyond the permitted level because they don't want to also take the steps they would have to take to achieve hydraulic neutrality.
What if they wanted to build up to the permitted level but could not achieve hydraulic neutrality?
I'll have to get into.
Yeah, you see what I mean?
Yeah, so I can answer at a general level about
Yes.
the approach the council's taken. When you get down to the specifics, we'll have to go through the rules to work it through, and maybe it will help you to understand the approach for us to select some examples
Sure.
in each of these different categories that we're talking about.
Yes.
And explain how the plan would apply to
Yes.
that.
If you can capture this, that would be useful.
No, I can do that.
But what I'm getting is that putting aside the character areas, character precincts, which definitely directly affect building height and density,
Mhm.
hazards, whether they're flood or coastal, heritage, district-wide rules, including Three Waters, all have an indirect impact on on density through the developability of the site.
Yes. Well, look, I think that providing something like that will be helpful.
Well,
it's also relevant to the vexed question of ISPP versus Schedule 1, Policy 1, because I don't know if you recall hearing Stream 1, but that was also part of my answer to when the council was putting something into the ISPP, part of its decision-making process was to ask, does the imposition of this topic or rule or whatever it is rely on Policy 4?
Yep.
And so there are some, we had some discussion about, well, why has heritage gone into it as opposed to
SNAs.
SNAs, exactly. And so the answer is SNAs don't change the building standards or the permitted activity standard or anything like that. You just have a separate consent requirement if you want to remove vegetation.
yes.
Whereas heritage, different approach.
Yes, and in some of those matters, particularly the hazard one, like high hazard areas, the policy framework and the activity status can be quite difficult.
Yes.
Yes.
And but just pushing that, looking at 77I says that I need to extend the following qualifying that as the present need to give effect to a designation, but only in relation to land subject to the designation. How would a designation ever affect the sense that we're talking about height and density standards? Because it's always operated as just another layer.
It probably couldn't, in the sense that if the designation, the only reason that the underlying rules ever come to the fore is if the designation is not going to be implemented, if the designation is being uplifted. Well, that's not entirely
Or
true
unless
because
the requiring authority
gives
agrees.
permission. That's right. So I suppose feasibly it might, in that rare or unusual sense that situation that somebody's proposing to do something on land that's subject to a designation and gets permission, the underlying rules will apply, and the council might decide to change those rules, reduce the MDRS standards or whatever, but on account of the designation being there.
But it's giving effect to the designation. That sounds like an indirect consequence rather than a direct consequence you're talking about. It's one of life's great imponderables.
Just to finish that discussion, though, I guess one of the other options that was available to the council presumably was they could have zoned out the land, say for the high hazard areas. They could have created a coastal zone as opposed to having a residential zone subject to an overlay.
Yes.
And they've chosen not to do that.
Yes. Well, the qualifying matter, the legislation about identification and establishment of a qualifying matter leaves it up to the plan creation process to decide what is the best way of then giving effect to the qualifying matter to the least extent necessary to accommodate it.
Yes.
And it might be in a particular case you create a specific zone. It might be in another way you apply an overlay. It leaves it up to the plan drafters to
certainly
do
in
that.
the prior context. And sorry for just going back to that because it's just that it's fresh in our mind. The regional council sought a coastal zone over high hazard areas in their original submission.
Yes.
I don't know what approach they've taken in the Wellington context. I haven't got to that in my reading yet. Is there anything in the section 32 that addresses that zoning out option that you're aware of?
Not that I'm aware of, but I mean, I can go and look.
Yeah.
It's a little bit like the question, why is it character precincts instead of an overlay?
Yeah, although given it was a live option, it's a fundamental, I mean, presumably that was one of the initial tasks that the council addressed. How are we going to deliver on these qualifying matters? Are we going to do it through overlays, precincts, or different zones? Yeah. Okay. If you could check though, that would be useful.
I'm wondering if providing that it will be relevant to most, if not all, future hearing streams. It's not specific to this hearing. And it's also relevant to the ISPP versus Schedule 1 issue. So it might be helpful for us to provide that alongside the reply for hearing stream 1. Or perhaps you don't mind and it can come when it comes. But
yeah, just be aware that I've asked Mr. Patterson for some other information on shading in relation to section 32.
And that's I can loop that in, but the reason I say that is that probably the council officer with the best knowledge of this is Mr. McCutcheon, who you heard from in the first hearing stream.
Like if it's convenient to put in the stream 1 reply, that's going to be more accessible to much greater range of parties.
Yes.
Okay. Sorry about that, Trevor. That was an interruption.
Going to the discussion of HRZ01, made rapid progress. It's only 20 to 5. We're up to the first objective. Yep. Not even that.
124.
124.
In the introduction for the HRZ, you have suggested to take out Johnsonville and Kinepuru and Tawa, and you refer to railway stations. these railway stations, are they any railway stations or are they RTS?
I think this is premised on the recommendation that Johnsonville is RTS, and so there are no others. All the railway stations are, on that assumption, are.
Yeah, that's correct. I'm just reading the
Okay.
evidence, and
Yep.
yeah, I concur with that.
Okay, yep, thank you.
Wondering, just while I've questions, caused me to have another look at this. I was going to ask this question in the context of objective 1, but I'll ask it in the context of the introduction. Is the at least 6 stories appropriate in that context? By enabling multi-unit housing of at least 6 stories, it enables multi-unit housing at 4 stories. And 5. So why at least? Should it be
The change there for at least 6 stories was just to acknowledge that there is a consenting pathway to go through as an RDA.
But there's a consenting pathway at 4 too.
There is, but I think that at least 6 stories also aligns with that direction from the higher order legislation, MPSUD.
Is there any cap that isn't an RDA? Any cap of multi-unit housing that isn't an RDA?
No.
Why do we need any reference to how many stories it is?
I think it signals the level of development that we're anticipating within the high density residential zone, which is at least 6 stories and greater where it can be achieved.
Well, why don't you say that? Of up to 6 stories or greater. Because the thing that's actuating the splitters is that the implication that it's no more than 6. That's where they're coming from.
It does at least.
Well, I just think, well, the question for you is, is at least factually correct? Because I'm suggesting to you that on the face of it, it's not. And therefore how you address the submission and at the same time say something that's factually correct.
So not factually correct because you can go below 6 stories?
Yes. Right. Because at least says, because that would only be correct if there was a minimum, which of course there is in the central city, a minimum height.
Yeah.
But there isn't in the HRZ. And a multi-unit development is defined to be 4 or more.
Yes.
4 or more units, which may or may not be 4 or more stories.
Yeah, I'm just thinking about that, and I can see your argument, and I do think there probably is scope there to consider that.
This submission, this recommendations come out of your partial acceptance of the KO
Yes.
submission that sought the wording of up to 6 stories in all areas of the HRZ and up to 12 stories in areas of high accessibility to key centres. And you've said that this is a preferable wording, giving partial relief to that.
Yeah, so it's partial relief, and that's because we don't agree with the second part of what they're asking for.
Well, that was going to be my next question, presumably.
What's the second part of what they're asking for?
That being what you just referenced about 12 stories and accessibility to centres and
yes,
yeah. So that approach, I think that's a general approach that Kāinga Water is trying to take, which I don't agree with in the plan. I consider that the zoning already reflects the accessibility to centres and public transport, and that's reflected in the different height limits also. So that's why I don't agree with that approach.
Well, I think that we should leave it that you're going to consider saying something like up to 6 or more.
Yeah, I think I will certainly agree to consider that. Yeah.
The the evidence of Dr. Zamani prior to the afternoon tea adjournment might suggest that you need to consider on an evidential basis at least whether further modification of that introduction might be necessary.
Well, I suppose that if it's 6 or more,
Yes.
that leaves a lot of scope for movement.
It's just that Mr. Patterson used the word "we" again in terms of, and I'm not trying to be critical, but
No, it's fair
we
enough.
heard from your witness prior to the tea interval that he's not really too worried about height.
That's correct.
And of course, the question to be answered is where do you sit on that?
Yeah.
And do you differ from Mr. Hill? And this is the first opportunity I've got to ask you that.
Yeah.
Don't expect an answer right now, but it's very much a live question.
Yes, they don't ask. We don't need an answer now, but we will need an answer tomorrow. And we'll just reach to that. Objective 1. This is a common feature of this plan. First objective is entitled purpose. Is the purpose of a zone an objective? Is it to me, it's not an outcome. And is this framed as, if this is a description of what the zone does, is that an objective? Is that an outcome? So it's a matter of drafting style. So as I'm not mere lawyer, I'll leave those such arcane issues to the planners, but so I'm waiting with interest.
I would argue that it is an objective. It does signal what the high density residential zone is trying to achieve in the sense of predominantly residential activities and a variety of housing types and sizes.
Well, should it say, rather than the HDRZ provides for, should it say the outcome the HDZ seeks to provide is something like that? Because this, as I say, as it's written, it's a description of the zone. It's not a description of the, it's not a big shift, but say factually, what's the end result? It's not what the zone provides for, it's what's actually going to happen.
Yeah, sure.
On the ground.
Yeah, I mean, I stand by my argument. I will look into it.
And the other thing is whether purpose is the appropriate heading for an objective.
Yeah, that's the as you mentioned, that's the approach taken.
Yeah. Well, since this is the first objective, we've had the opportunity to talk to the representatives of the council team about.
Yeah.
Start with number 1.
Yeah. No. Yeah.
So I'll just hope you're going to think about that.
Yes.
And this also has the same issue, number 2, of at least 6-story buildings. That is the planned urban character. Is it correct to say it's of at least 6 stories, whereas the planned urban character, a range of, like, I'm thinking of those other objectives that talk about different types, different heights, different typologies.
Sorry, what reference were you referring to now?
Well, the thing I'm focusing on is the statement that the planned urban built content character
Yeah.
is at least 6-story buildings.
Yeah.
Like certainly the zone envisages at least 6-story
That's right.
buildings. But is that the planned urban built character, that everything's going to be 6 or more? Like you would certainly say that in the city centre zone because there's a minimum
Well, I think,
height limit.
I mean, that is what the high density residential zone has planned for. Whether or not it is realised is, up to individual applicants. However, that is what the high density residential zone has planned for. Noting that, it's if people don't want to go to that 6 stories, then they don't have to, but it provides for it.
But that's a different thing saying it provides for it, yes, but is that what it's planning for? And in the inevitable, when that's not achieved, because assuredly it won't be, not on every site, does that mean that, well, what's the consequence of an objective in a plan that isn't achieved? Is that in the so what category? Or does that then require further action from the council to take further steps to achieve the objective? That's certainly what you would say in a regional plan, because there's a whole, because that's what all what freshwater management is all built on now. If you're not achieving your objectives, then you can do something about it to ensure they are achieved. But does the same apply in a district plan?
Well, you certainly have to do an assessment of your objectives through a resource consent process. And then through that process, you can argue for why you are or are not achieving that 6 stories. And why that particular instance, why it is or why it's not. So case by case.
My next one was 172. Yes, this is about HRZP1. I wondered if there was, we're happy with the existing wording effectively, I think, because you're focusing on the word anticipated. I wondered about some combination of words that draws that out a little. Something like is consistent with the amenity values anticipated as a result of the plan built form. Because that's going Laura's point, that it's goes back to the point that Mr. Wellington was. That change to the plan built form will involve detraction of amenity values. They don't want to end up in endless arguments, focusing on an objective that talks about amenity values.
Yeah, my argument there, and that I still stand by, is that anticipated amenity values, in my view, captures the wording planned built form. What's anticipated through the high density residential zone is that 6 stories. That is the planned built form, in my view.
Your suggested relief. At B2. Should that be other residential buildings, given that 3-story attached and detached dwellings and low-rise apartments are obviously residential buildings?
Don't quite follow the argument there.
Well, point being, you're saying what's a low-rise apartment anyway? Like, sorry, answer question with question. The thing that I was reading was saying variety of housing typologies. Yep, fine, including 3-story attached and detached dwellings, low-rise apartments, and the question is whether that should be other residential buildings of, and then there's an issue to me of same issue as previously. Is it at least 6 stories in height? If your point is that an RDA is enabling, then there's no limit on the height. They're all RDAs.
Yeah, I mean, my argument still stands, and I mean, it's the same reason why I've recommended the same change to HRZP2, of that at least 6 stories. In terms of that clarification around other residential buildings, I consider that the range of dwelling types or development types mentioned there was to try and capture as much as possible. Whether or not you can add the word other residential buildings, I'm happy to look into that.
Well, as I think about that.
Yeah.
I think we've probably done enough for one day. 3 minutes to 5. Right, June on that basis, we're up to. Trying to write this down. Halfway down before policy HRZP3. Thank you all, and for your assistance today. Been an interesting day, and we'll be back 9 AM, bright-eyed, bush-tailed.
Thank you.